The June 12th, 2024 Arlington County Board of Zoning Appeals is now in session. Good evening and welcome. I am Richard Kaplan, Chair of the Board of Zoning Appeals. The board is made up of 5 citizens appointed by the Circuit Court. Tonight, in addition to myself, we have Vice Chair Inta Malice, Judy Freshman, Portia Clark, and Carol McCoskry. Also present is the professional staff, including Blake Bowen, Board of Zoning Appeals Coordinator, Brett Goldberg, BZA Associate Planner, and I'm assuming Stephen Rizzi, Zoning Prims Supervisor. To avoid disruptions, we ask that you place your mobile devices in silent mode, which I will do now. Before we begin tonight's hearing, I will discuss the board's powers and procedures for tonight's hearing. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance, adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend regulations set forth in the ordinance. That authority rests solely with the county board. This board does have the authority to do 3 things. First, the BZA can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. In order to approve a use permit, the Arlington zoning ordinance requires that this board find that the proposal will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to the property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. In making these findings, the BZA shall consider whether the modification will promote compatibility of the development with the surrounding neighborhood because of the structure's overall size, footprint, and placement are similar to those of the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary and in the public interest, including but not limited to the duration of the use permit. This board does not have the authority to grant use permits to modify requirements for expanded housing option developments. Second, the BZA can grant variances from the specific requirements of the zoning ordinance. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that the strict application of the ordinance would unreasonably restrict the utilization of the property, and the need for a variance would not be shared generally by other properties, and such variance is not contrary to the purposes of the ordinance, or that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested by or on behalf of a person with a disability. In all variance cases, the property for which the variance is being requested was acquired in good faith, and any hardship was not created by the applicant. That the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area. That the condition or situation of the property concerned is not of so general or reoccurring in nature as to make reasonably practical the adoption of an amendment to the ordinance. That the granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. Third, the BZA has the power to hear and decide appeals of the zoning administrator or from any order, requirement, decision, or determination made by any other administrative officer in the administration or enforcement of Title 15.2, Article 7 of the Code of Virginia. In exercising its powers, the board may reverse or affirm wholly or in part, or may modify an order, requirement, decision, or determination appealed. The determination of the administrative officer or zoning official shall be presumed correct by the BZA. The appellant has the burden of proof to rebut the presumption of correctness by a preponderance of the evidence. The board shall consider any applicable ordinance, laws, and regulations in making its decision and must base our judgment on whether the administrative officer was correct. The concurring vote of a majority of the membership of the board shall be necessary to reverse any order or determination. Now on to tonight's hybrid hearing. For those who are participating in person, on the front of the table, you will find a QR code linking to a copy of the application package, including the staff report for each case before us this evening. For those participating virtually, a copy of each application package can be found in the Arlington County BZA website. There is also a link in the chat for the application packages. I recommend that if you have not yet seen that report for your case, that you review that report before your case is called. If you are attending virtually and lose connectivity, please reconnect with us by phone. If you are attending via Teams, please keep yourself muted and cameras off until called upon. Turn off the sound on any other devices around you to minimize interference. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located in the meeting command bar. County staff does not have the ability to unmute you. The meeting chat is active for technical support assistance only. The meeting chat should not be used for discussion, public comments, questions about agenda items, or requests for more information. All public comments must be shared verbally or have been previously provided in writing for the record during the assigned public testimony period. This evening, staff will call each case and will provide a brief staff report and recommendation. Next, board members will ask questions of staff that they may have. Applicants or their representative will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the item will be called. Speakers must fill out a speaker slip in person or online. It is available on the table in front of the room. After we hear from speakers for and against the proposal, the board may permit an applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit any cross-examination or direct questioning by others. For tonight's hearing, this board has deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, 3 minutes for representatives of organizations, and 2 minutes for individuals as sufficient. As we have a large number of speakers signed up tonight, we ask that these limits are adhered to. After the board has gathered all information we need and have discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority of our membership is needed to approve any motion. Please be respectful of the time allotted. This is a public forum and tonight's meeting will be recorded and posted on the county's website. All information associated with tonight's hearing, whether spoken or written, is subject to the Freedom of Information Act requirements. Any appeals from the decision of this board must be made to the circuit court in accordance with state law. After your case is heard, you are welcome to stay for the balance of the session or leave at your convenience. With that said, Mr. Bowen, a couple administrative matters to address. I believe that appeal ZAPP 24-00007 is ready to be scheduled. Is that correct?
Yes, Mr. Kaplan, we have received application fees for that appeal.
That being the case, I would like to seek unanimous consent from my colleagues to schedule that appeal ZAPP 24-0007 for our September 18th BZA hearing. Hearing no objections, that will be scheduled. I want to, as a reminder to my colleagues and the public, at the beginning of the year, this board approved a slate of carryover BZA hearings so that we can decide which day to hold appeals based on what that agenda ends up looking like, and this board can make a determination on that if we wish to change that at a further hearing. Mr. Bowen, secondly, I understand that we have two appeals, ZAPP 24-0005 and ZAPP 24-0006, which are two appeals of substantially similar issues that are not yet ready to be scheduled as the appeals fees have not been heard. Last month, we tentatively scheduled these appeals for our September 18th hearing. Would staff object if we were to schedule these items for the September 18th hearing, a hearing for dismissal if the fees have not been paid prior to 60 days of our September 18th hearing, or a hearing on the merits if the fees have been paid prior to the 60 days prior to that hearing?
The payment of fees is being coordinated as potentially being consolidated into one matter with the county attorney's office. So I don't have absolute certainty that that date will work, but I believe you have tentatively scheduled them for September previously. So it doesn't represent a substantial change. So I believe, and my best guess is that would be acceptable. Yes.
And it sounds like this is not a dispute on whether the fees will be paid. It's just a matter of what the appropriate fees are.
I believe that, yes.
So staff should, regardless of what happens, should have their 2-month prep period prior to the actual hearing of the case. And seeing as how this board is on recess in August, my preference, if my colleagues agree, would be to get that scheduled in that manner. So I would like to seek unanimous consent for the scheduling of ZAPP 24-00005 and 6 for the September 18th BZA hearing, with the caveat that if fees aren't paid 60 days prior, it would be a hearing for this board to dismiss those appeals. And if the fees are paid 60 days prior, it would be a hearing on the merits as normal, as typical.
Mr. Chairman.
Ms. Malice.
I have no objection, but just to mention the carryover date, the regular date is the 18th and the carryover date is the 19th.
That's my recollection.
Okay.
Mr. Chairman,
Ms. Freshman.
at the moment, all things being equal, we're going to have 3 appeals on the same night.
We are going to have 3 appeals, but these 2 appeals are of this the identical facts. So I think it's really going to be substantially 2 appeals.
Well, still the timing, the allotted timing for presentations, et cetera, might still be individual. I'm just pointing it out that.
Yeah,
Not-
I think.
Not if we don't have them, if we don't meet in August, we're likely to have a fairly significant agenda in September. I don't think even 2 appeals, let alone 3, might be appropriate on the same night.
And we have scheduled a carryover night. So if we need to make use of that, we can either do so automatically or prior to the hearing, we could divvy up cases among those 2 nights. So is that no objection with that being the case? Hearing no objection, they are scheduled. Mr. Bowen, I believe that is all the administrative matters I have. Did you have anything else to take care of, or are we ready for the first case?
Now at the moment, I believe we can proceed to the first case.
Excellent.
All right, with that, I'll read the first case. The first case is a carryover case. It is case number V-11929-23-UP-1, a use permit request by Anne Marie Zarega, the owner, to permit a right side setback of 3 feet to a new window well instead of 5 feet to the window well as required, regarding a new window well for an existing 1-family dwelling in the R6 zoning district on the premises known as 416 South Adams Street within the Penrose Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. Please note that we have supplemental material for this case, including a supplemental statement of justification submitted by the applicant, as well as a written statement that was read aloud at the April 2024 BZA hearing. And then we also have 4 speakers who are signed up to speak on this case.
Thank you, Mr. Bowen. Sorry, my computer monitor is off. Do we have any questions for staff? Ms. Malice.
In this evening's packet was a notice of violation that I noticed was not in the packet for when this was heard previously. I wondered who submitted that documentation.
Ms. Malice, can you point me to which page in the packet you're talking about?
It would be page 22.
I believe that particular document was from the applicant, noting a building code violation, which prompted the submission of the BZA application.
Okay, so the applicant submitted that. Was that information that staff did not have before?
I believe this was included in the previous packet. I'll have to take a look, though.
That's all right, but that answers my question.
Okay, thank you.
Any further questions for staff? I have a couple. Mr. Goldberg, I'm sorry, I missed the pictures because my monitor was off. But Mike, without having seen the pictures, are the pictures the same as we saw last month? Or have they been updated?
Yes, Mr. Kaplan, these were the same photos from included in the May 15th BZA PowerPoint.
I might ask you to run through them later.
Okay.
Mr. Bowen or Mr. Goldberg, I know I raised an issue at the last hearing on the plat, and I see that we have a new plat, thankfully. But my question is, and I know I raised this issue last time as well, is that on a normal case, window well or any case, we would typically have the exact placement of the proposed window well or addition or any feature that would be added. And here I just see a red Sharpie with no specific setbacks and no actual locations. So assuming that there's going to be if this board approves this, assuming that it's built, that there would be I don't want to say wall check, but a final plat to confirm, a final survey to confirm the actual placement meets what this board would approve. But I don't see how that could be possible without more specific measurements.
Mr. Kaplan, so on the existing plat, we do see a measurement of depending on which plat you're looking at, 6.1 feet or 6 feet. And then we have a specification.
For the setback? Are you referring to the 6.1 setback on
the existing, yeah, right side setback?
Right. But we don't know where this window well will be built.
The window well, we also have a spec sheet showing the depth of the window well is 3 feet. So long as the window well, it meets the potentially approved side setback of the BZA and the required rear setbacks and front setbacks of the zoning ordinance, the other placement would be considered by right and would not be subject to the use permit.
Okay, so from staff's perspective, you don't care where on that wall it fits as long as it is 25 feet from the front, probably 25 feet from the back, and what the amount that this applicant is asking for as per use permit.
Yes, as long as it's similar to any other BZA case, as long as the other features are in by right locations, they would not be, pertinent to the potential approval of the BZA use permit.
And if just like any other case, if that window well is placed in a position where it's an inch off, then that applicant will likely be before us if we approve it tonight again.
If the placement of the window well does not meet a setback approved by the BZA, for instance, if it was be closer than 3 feet to the property line, that could be cause to return to the BZA for a subsequent BZA use permit approval.
Okay, I'm just, I think that this board is used to seeing more definite locations for these things. Ms. McCruskey.
So is there, and I'm trying to look on these documents quickly, but is there something that shows us the width of the window well along the wall?
I believe there was a specification sheet. Let me scroll to the page in the packet where that is, which had those dimensions.
36 inch.
Yeah, I think that's right. I think it's 36 inches.
Okay, so it's going to be 3 feet by 3 feet essentially.
Yeah, pages 17 and 18 of the online materials show some dimensions and illustrations of the window well.
So it's unclear to me what the 41,
as well as 19.
It's unclear to me what the 41-inch measurement is, though.
I think that's the height from the basement.
Oh,
floor.
yeah. Yes, sorry. I will turn sideways.
But that's why.
Oh, then that's 36 inches high. No, you're right.
Nothing really. So, but I guess, and maybe we can get
Mr. Rizzi has his hand up. Maybe he wants to address this comment.
Sorry, yes, the width is shown on page 19 as 52 inches wide.
Oh, I see. Thank you.
Page 19.
It's like
yes.
Shows the bathtub.
Thank you. Okay.
Thank you.
I think we're ready for the applicant. Is the applicant with us or online?
Online.
Can you hear me? Can you hear me?
We can.
Hello. I'm sorry I'm not before you in person, but I'm disabled and it's very hard for me to get around. The variance we're requesting is for an escape window out of the bedroom in the basement. I've lived here 40 years, and friends, families, and renters have lived in the basement for about the last 20 years. Happily, I might add. And then the county code enforcement, responding to a complaint, surveyed and verified, and violated the house for not having an escape window out of the basement bedroom. So I contracted with the contractor, reliable. The new window, there will be no change to the appearance of the wall because all the changes are underground. In other words, the current window is 20 inches above ground, and the new window will be 40 inches. 20 inches will be below ground, and the same 20 inches will still be above ground. The only difference, there'll be no change to the footprint of the property. The only change would be a steel grate where there used to be dirt because they're digging down for the well. So there'll be a steel grate with a Lexan cover over it to protect people walking around the yard. The plans have been approved, reviewed, and validated by the Arlington Community Planning, Housing, and Development Group. And the objections from the last hearing were, the only two that were really related to the window were that it needed a more recent plat, and there was concern about the generator that sits on that side of the house. Well, the generator is mobile, it's portable, and it is not encroach on the property. And that was verified by another county code enforcement inspector in May. They were responding to a complaint by one of the people who's testifying tonight that I don't have an escape window in the basement, after they opposed putting an escape window in the basement at the April meeting. So the inspector came, reviewed everything, and verified that the generator is portable, it's of no threat to anybody. And she examined the window, everything was fine. The other objections are mostly personal and are irrelevant to the question at hand. The motives of these, I'm going to stop right there, and I'll be pleased to answer any questions.
Thank you. Thank you. Do my colleagues have questions for this applicant?
Not at this time.
Mr. Bowen, why don't we hear from speakers signed up? So can you call the first speaker?
Yes, first speaker is Mary. I apologize, I do not know how to pronounce Mary's last name.
Can you step up and use the microphone?
Can you hear me now? Yes. My name is Mary Kvitash.
Pull it closer to you, ma'am. You can pull it closer to you. You can pull it closer to you so you don't have to lean. There you go.
How's this? My name is Mary Kvitashvili. I live at 416 South Adams Street, across the street from the Zarega residence. I'm writing in response to case of V-11929-23-UP1 carryover for the June 12, 24 BZA hearing. As a close by property owner to 416 South Adams Street, I received a notice regarding a use permit request in the mail, and I would like to state the following as a response. Sorry about my voice. I completely concur with the facts of the letters written by my neighbors at 408, 412, and the legal owner of 420 South Adams Street. I do not support this variance request, and I request that the application be denied for the following reasons. As I have previously stated, Ms. Zarega states in her letter that her application is for an existing rented basement apartment.
I do not support expansion of an already illegal rental property. Most importantly, I continue to be concerned for the safety of the residents of 412 South Adams Street who are next door to Ms. Zarega. If this request is granted, it will give her agent, David Keller, the go-ahead to violate the protective order that is in place against him by the household of 412. I remind you that Keller pled guilty to violating the protective order that I have against him just a few months ago. I will oppose this variance as long as Keller is a resident and the safety and security of my neighbors and friends at 412 and 408 is compromised. The new survey provided by Ms. Zarega lacks specificity and details requested by the board in the last minute. The new survey nor any drawing provided by Ms. Zarega do not show any level of architectural detail or specificity as to where the egress window will be installed. There's a hand-drawn red box and arrow scribbled in pointing to a window installation with no precise indication of where exactly the window will be installed. There's no mention of the window well, nor are there any indications or drawings of the existing generator with shed. Ms. Zarega told Inspector Colbert with code enforcement on May 13th that the space where the egress window is to be installed is not an apartment. At the same time, she's telling the BZA it is. If you look up her address on Zillow, it brings up the basement apartment with pictures. This space should not be occupied or rented until it can be brought into compliance.
Thank you.
Thank you.
Next speaker is Ms. Kennett.
Hello. My name is Christina Kinnett. I live at 408 South Adams Street, and my mother lives at 412 South Adams Street. You asked, would the proposal adversely affect the health or safety of persons residing in the neighborhood? And I'm here because I'm concerned about my mother's safety and my family's safety. Ms. Zarega has Mr. Keller, who resides at 416 South Adams Street, manage her property. He acts as her agent and overseeing general care and maintenance of the property. My husband has an active protective order against Mr. Keller. The protective order includes by name, my household at 408, my mother's household at 412, and my daughter. In this order, Mr. Keller is to have no contact whatsoever, including nonverbal. He must remain 500 feet away from my family, with the exception of ingress and egress to his property, as well as not engage in any conduct from his property directed at my family that is intended to provoke, harass, or intimidate, including gestures. Given Mr. Keller's documented behavior, any potential interaction is a direct violation of the protective order and puts my family's safety at risk. After the hearing in April, I asked Mr. Bowen about what was meant when board members mentioned that further action or review or investigation was needed. He advised that we should file a complaint with code enforcement and zoning, as the BZA does not initiate that action. So we did. Inspector Colbert from Code Enforcement went out to the property May 13th. Ms. Zarega refused her entry inside the property and advised Inspector Colbert that the space was not an apartment. Ms. Zarega states it's an apartment in her documentation to the BZA, but then later advises Code Enforcement that it's not an apartment. It cannot be both. In the new documents that were uploaded for the June agenda, it shows there's an open code violation from August 2023. Code enforcement has advised me that the concerns regarding the property are currently being evaluated, and Inspector Wilson's open complaint is being investigated. A zoning complaint has also been opened regarding whether the basement apartment is compliant. We have also advised zoning of the placement of the AC units on the new survey. Mr. Keller is uncontrollable. He intentionally violates legal authority and then asks for relief. Whatever you approve, he will use to hurt us. I will not support this variance while Mr. Keller is in residence. We ask that you deny this variance. Thank you.
Thank you.
Mr. Chairman, may I ask
Ms. Malice.
speaker a quick question?
Yes. Can you come back up for a question?
Thank you. In your testimony, you said that Inspector Colbert, that Ms. Zarega spoke with Inspector Colbert. How did you come by that information?
That's in the notes that she posted when she closed the inspection report on the permit Arlington. If you look up on permit Arlington, you can see the inspector's notes.
Okay, that's not a document that we have right now, is that? Okay. So anyway, I'm confused because there was an inspection of the property in August of 23.
We were just made aware of that when she uploaded those documents.
Right.
A
So
week ago.
inspector did go in and look at the apartment at that time.
Inspector Wilson did, yes.
Okay. And that still is open.
It is, apparently it had been closed. It's now back in review and it's back open.
Okay.
And code enforcement is dealing with that.
All right. Thank you.
Ms. Morse.
My name is Judy Morse, and I am speaking this evening in opposition to the requested variance at 416 South Adams Street. I live next door at 412, and the proposed egress window is just feet away from my property. I am included on a protective order where one of 416's occupants, Mr. Dave Keller, who acts as agent and property manager, is required to stay 500 feet from me and my immediate family, except for ingress and egress from the 416 property. Any interaction with Mr. Keller further endangers me and my family. I've had a fence and landscaping added between the two properties to prevent Mr. Keller from entering my property. I expressed many concerns with the submitted documentation for this variance in the April meeting, and not much has changed since then. There's a new survey plat done in late May, but it doesn't show the structures on the side where the egress window is proposed. Notations on the survey do not identify where it will go and if it will fit properly in the limited confined space. Outside the window, directly adjacent to the proposed well, there is a gasoline generator. We discussed that, I guess, and a shed storing firewood on the other side, structures that are not on any plans or floor plans submitted. Location of the drawings do not show the finished rental basement apartment dimensions, but the Zillow listing indeed, and I provided you with a screenshot of the Zillow listing showing the apartment and many photos from within it. As I stated previously, I and 4 immediate family members are included on that protective order. And except for ingress and egress from the property, Mr. Keller is required to stay 500 feet from us. Approving this project further endangers me and my family, and I'm asking that this be denied.
Thank you, Ms. Morse. Any questions for Ms. Morse? I just had one quick question regarding the Zillow listing.
Yeah.
Just a quick look on the Zillow listing that this doesn't appear to be a apartment listing. I don't see like a price or anything. It just seems to be just a Zillow off market.
That one.
So I just wanted to clarify that for the record.
It's just there are additional things on that listing. They were listing it at $15.99 per month. And the history, which is below all of this, indicates when the listing was added and removed when different tenants rented and departed the property.
Thank you.
Thank you.
Mr. Kennett.
My name is Tommy Kennett. I live at 408 South Adams Street, and I'm opposing this variance. As my wife stated, I have an active protective order against Mr. Keller, who resides at 416 South Adams Street. Ms. Zarega has knowingly rented this apartment with a non-compliant bedroom, endangering the tenant's life. The newest documents uploaded for this second hearing show that a code enforcement violation for this basement bedroom was issued in August of 2023 when a different renter was in that space. The violation requires them to add an egress window or cease using the space as a bedroom, yet they rent it out anyway. The plat does not show proposed improvements drawn to scale with dimensions or setbacks indicated, which was requested by the BZA. It still does not show the structures directly around the proposed well site. There are no dimensions for the shed that houses the portable generator or the distance of the shed to the fence. Virginia Residential Code R310.1 requires a minimum width of 36 inches that opens to a public way. The floor plan shows only one window, not two. It's not to scale, does not show any dimensions of that apartment. The drawings of the proposed construction are not to scale, do not show any dimensions of the window well. The window, if constructed for drawings, a double hung window with a saw cut opening 35 by 41 would not satisfy requirement of an egress window. Virginia Residential Code R310.2.1 states a minimum opening of 24 inches. This space is not part of the applicant's living space, but a separate basement apartment that has rented, providing income. It should not be rented or occupied until the space can be brought into compliance. I oppose this variance as long as my family's safety and security are compromised by Mr. Keller. We ask you to deny this application.
Thank you, sir. Any additional questions for my colleagues or discussion?
I'll just.
Please, Ms. McCoskey.
One thing I think that's important here is that obviously there's a lot of concern about a particular resident, Mr. Keller, in the house. And, our decision does not have to do with who's actually living there at the time. And we need to consider the approval of the use permit independently of that, because if this is permitted, it's allowed there no matter who lives in the house. So, I think we all recognize that there's a big issue here in this neighborhood, but do keep in mind that our decision should be based more on the standards of the use permit. And I will say, from my perspective, I think this is a difficult one because this is such a small space. It's obviously already quite cluttered, but I kind of think that given that what's being put in is just a window well and an exit window, it's probably better to have that in there for safety purposes and to approve a use permit for that to be in there for safety purposes. And I think the other issues that are out there, one of which may be whether there's a legal or illegal unit in there, those need to be definitely addressed and would not be approved. But for any bedroom, you would need that window well.
Thank you. Any further comments from my colleagues?
Mr. Chairman, yeah, I substantially agree with my colleague, Ms. McCroskey, that the issues are separate. We're talking about an improvement to a structure and not, who resides there. I am a little confused about the code enforcement issues going on here, but I think that that's for code enforcement to straighten out. The fact that there's maybe been 2 inspections or maybe 1, but I don't think that's relevant either. If code enforcement has actually been in the unit and has seen the setup, it's up to them to raise that as an issue, because we really can't handle code enforcement issues here.
Thank you, Ms. Malice. For me, this is a very close call, and I think I see where my colleagues are going. On one hand, we have very real concerns of neighbors who the applicant has to meet the requirement that the proposal not be detrimental to the public welfare. And even interpreting that even very narrowly in this case, I think that there is an issue there. But on the other hand, I'm not sure that this board wants to be weighing that standard versus the very real safety hazard standard. And regardless of how this basement is used, whether it adheres to the Arlington County ordinances or not, I think it's beyond the purview of this board, because we get these window well cases all the time, regardless of if it's an apartment. Any house can just have that requirement. I will propose to my colleagues, although I suspect I will not get much support, if my colleagues would entertain a condition that this window well egress be used only for emergency purposes, which I think would assuage a lot of the angst we have heard from tonight. And I would support that, but I don't know if my colleagues would.
Mr. Chairman.
Ms. Freshman.
I think by definition, it would only be used for emergencies. I can't foresee someone actually going in and out that way. I think the applicant clearly has been violating the code by renting an apartment that's illegal in that it doesn't have a proper egress from the basement. So having been cited for that, the remedy is to put in the window well. And I presume that even though we don't appear to have drawings that have real measurements, I'm assuming that the staff is satisfied that the separation to the property line is acceptable. I don't know how we can actually judge that, given a lot of the other cases where we negotiate over inches on side setbacks. So I'm a little confused about why this remains vague. But on balance, I think that if code enforcement requires this in order to be compliant for continuing behavior that heretofore has not been legal, I think that is entirely a separate issue from the safety issue, about which I have a lot of sympathy, but as you've stated, is not part of our purview.
Ms. McCroskey.
Yeah, I think the one thing that is going to ensure that the location of the window is in or doesn't go too far out is that the resolution provides for a setback of 3 feet, so it can't go closer than 3 feet. And when we're ready, I would propose that in our motion, we make a little bit more specific reference to the cut sheets for the window well so that we get those dimensions included, because I think that's important, what the width is, the depth and all that. And it may well be in there, but I would specifically add it to in a motion.
Thank you. Would someone like to make a motion?
I'm prepared to make a motion.
Ms. Malice.
I move that the Board of Zoning Appeals approve the attached proposed resolution granting use permit V-11929-23-UP-1, subject to the conditions listed, with the addition in the first resolved item that the applicants agree that the window well shall be constructed in accordance with the footprint shown on the survey and the architectural drawings specifically the cut sheets that showed the dimensions of the window well, and the rest remains the same.
Thank you, Ms. Malice.
Second.
A motion made by Ms. Malice, a motion as amended by Ms. Malice, seconded by Ms. Freshman. Any further discussion? I'll just say that I do not plan on supporting this because I think we can easily add a very small condition, as I talked about earlier. I have also been I have also had a restraining order against a neighbor in a previous life. So I am very sympathetic to the neighbor's concerns, and I think that this window well, can be used for more than just egress. And so I have concerns about that, and I think we can easily address those concerns with a condition, and that condition could then be used, presumably to revoke the use permit or in district or circuit court if there were violations of that. So I think that it's a small tweak that I otherwise would support. So that being said, I'll call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. McCroskey?
Aye.
Chair votes no. Motion passes 5-0. 4-1. Mr. Bowen, can you please call the next case?
Yes, Mr. Kaplan, just a moment. The next case on the agenda is also a carryover item. This is case number V-11953-24-UP-1. A use permit request by Gail Douglas on behalf of Mid-Atlantic IRA LLC, the owner, to permit a street setback of 18 feet to the building wall, 15.7 feet to the building eave, and 11.5 feet to the stormwater planter instead of 25 feet to the building wall, 21 feet to the building eave and stormwater planter as required from 29th Street North, regarding a modification of first floor building walls to support second floor addition and a two-story rear addition to an existing one-family detached dwelling on a corner lot in the R8 zoning district on the premises known as 2817 North Ohio Street within the Williamsburg Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. I'll ask my colleague Brett if we have any in-person speaker slips for this case.
No, we do not.
Okay, in that case, we do not have any speaker slips or supplemental materials for this case.
Thank you, Mr. Bowen. My recollection is that we deferred this case at our last hearing for additional outreach. Is that what you remember?
Mm-hmm.
I believe that was certainly part of the request.
And do you know if additional outreach has come in since our last hearing?
To my knowledge, I believe we had, let me check.
Can I speak to that?
Well, I'm sorry, we'll get to you in 1 second.
Yeah, I think we have included additional in the actual application packet. I believe additional neighborhood outreach was submitted. I do recall seeing a BZA or seeing a comment from the neighbor. I believe her name was Janelle, who had previously objected to the project.
I see that is dated on May 14th.
The last page.
The last page, the last comment is dated May 14th, which I believe is after.
Or May 15th.
When was our last hearing?
It was on May 15th.
May 15th, so it was prior to. That's why I was asking if we had additional outreach, because
I believe on page 67.
67, great. Sorry, I'm putting you on the spot.
Oh, yeah, no, I just didn't know the specific page number.
Any additional questions for staff?
Yes, so just to circle back, so those are the only two that we've gotten.
I believe, yeah, there was not outreach from the neighbor Janelle previously who had objected.
Okay.
Or had, at least expressed an unwillingness to sign, perhaps. But now we do have consent from Janelle.
Okay, so
Markowski.
So different issue. In your discussion in the staff report, you referred to two different plats that you believe are substantially the same. I'd really be comfortable just deciding which plat we're going to go with here.
And maybe the applicant can speak to that.
Okay, and the applicant can choose which one that they're going to get approved. The one with the little bubbles around it seemed a little problematic to me.
Should I address that? Can I start with addressing that?
Yeah, why don't you?
Are there any other questions for staff?
I'm sorry.
Any other questions?
Yeah, any other? I assume there's no other questions for staff. Why don't you can take your statement.
So I appreciate you letting me come back so soon. I did, as I promised, I had the drawings to Blake on Monday morning, first thing. I did go back that night and double checked my records, and I think there had been some issues with your understanding of our outreach, because you had indicated that I had missed some houses, and when in fact we had hit about 10 houses all within a visual of our house. And I uploaded, to make it very clear, a map to Blake so that he knew exactly who we had uploaded to. And that package included a personal letter from myself, 3D renderings, because I know people have a hard time reading drawings. And so that went out to all the neighbors. At that time, we only received one from one neighbor saying that that was fine. And then I guess Janelle had sent something via back channels or via forums to you all. Since the last meeting, I went and met with Janelle in person. We spent about an hour talking with each other. She said that it was unfortunate because she thought it could have been resolved in about 10 minutes, because she didn't necessarily take exception to the garage or the work to the house. She just has had ongoing flooding issues and wanted to make sure that we were going to handle the water on the property respectfully. And then she had a bit of concerns about facing the wall of the garage, and we talked about that maybe in the future we rotate it. But since I wanted to get something through permitting and not wait till September, and you were very specific that you didn't want to see any revised drawings here tonight, I just took the garage entirely off the set of drawings. So that Tom and I can consider that in the future and come back if we need an additional variance or use permit for that. The reason why there are two plats is because your particular comment, Ms. Mouse, was that you didn't want to see revised drawings back here tonight. So I didn't know quite what to do with that. So one drawing just totally takes the garage and its associated stormwater off the set entirely. But then I didn't know if you would consider that as revised drawings. So the second set did something similar. I just circled it and I said not in contract for discussion purposes or whatever. I can't remember what I put there. So really that was our attempt, without being able to talk to you personally about what you would accept, our attempt of trying to deal with your comment. And in hindsight, I think probably your comment is you didn't want me to come back in a month with, huge changes to the addition and huge changes to the garage, but not being able to talk to you, I wasn't sure if that was the case. So right now, garage is off the table. In the meantime, we also have met with 4 of the neighbors in person. One person does not like to sign forms because he apparently did that one time before and it got him into trouble. So he refuses to sign, but he had no issues with it. And in fact,
sorry, can you
give us the addresses?
Yeah, we're all looking at the tax map. If you could give us the 4 people you spoke to.
one of them is the one that was very close. So it would have been down the hill, Brett, and it would have been the one that has it's on
The map is up
here
on front of you.
Oh, okay, great. So that would be, you're really testing my eyesight here. 2721, we talked to. 11, you already have the letter. Janelle at 6046. I think I uploaded the letter where she signed that she doesn't take exception. And then we talked to 6101, who is had no exception, is very glad we're keeping the trees. And then 6100 is currently somebody who is house sitting because the people are away visiting relatives in Florida. And they said, given what they know, the people who owned it, they wouldn't have taken exception. But all of those people, so the people who received packages, 6100. And I believe 6040. The other one I put on there. There were 10 that went out, correct?
Let me quickly check that detail.
And while he's checking, why don't you go back to the microphone? Just to be clear for the record, that the 4 people you spoke to had no objections.
Correct.
What was the address of the individual that would not sign? What was 6101? They had no objection, but they provided nothing.
6101, I believe they were Sorry, this was by memory. I believe that 6101 may have been house sitting and the
I
owners.
thought that was 6100.
Okay, then 6101 had no objections and they liked the fact that we were keeping the trees.
Okay.
And Ms. Douglas, I can confirm that on your map, you did show 6040, I believe, 29th Street North.
Yeah.
Any questions for this applicant?
So I guess it's for just to clarify with Mr. Bowen. Did you think there were two sets of plats in here?
I would defer that question to Mr. Rissy since he wrote the staff report and did the analysis.
Okay, because I thought that's what it said in the staff report.
I think he said that there were two options. And so one option, you're right, has the clouds. And that basically says that even though it's drawn, that it's not in contract. And I only did that as a follow-up to address your concern about not submitting different drawings.
So effectively, you're withdrawing the cloud drawing of the garage, right? So you're before us asking for the non-cloud version without the garage.
Correct.
Yeah.
Correct.
So page 25. has a
Page
good
25, that
Right, so
that
we-
would be helpful.
So we could reference that directly in our motion.
Yeah, I didn't realize both were going to be here. I gave them options because I figured they would know kind of the intent of her comments.
Yeah, it's
so-
not, right, so staff is just going to give us everything. They're not going to make decisions.
Yeah.
Okay, so the plat on page 25 of the staff report.
So really what's left that we're asking for is we have a non-compliant house on a corner lot where a corner of it is closer than the 25 feet. We're going to do a second floor addition, but because it's kind of the two width brick construction, in order to support the second floor and to deal with waterproofing, insulation, windows in different places, we're going to rebuild that first floor on top of an out of grade basement. And it's that replacement of the first floor that I think triggers the use permit. I did check with permitting and they said that as long as we kept the basement walls up to the first floor top plate, that we were fine and it wasn't considered a raise of a structure, that it was considered an addition. So, so it's just really that front corner and the eaves and the window trim that projects past the property line.
So, Mr.
Or not the property line, but the setback line.
So the garage did not require any relief?
The garage did require relief. It required, in a corner lot, you have a 10-foot setback from that rear property line. And in order to save that mature tree, we had shifted it, but I'm taking that off the plate right now and we'll deal with that as we get farther down.
And I believe that it also required separation between the main building as well. And that resulted in a staff recommendation of denial.
So Mr. Bowen, you rewrote the summary of the request here.
Mr. Rissy, the author of the report.
Staff rewrote to eliminate the things that had to do with the garage. Okay.
And I want to reiterate, we're well below the main building floor plate. We're not trying to grab extra floor plate. We are below the lot percentage coverage. So we're not trying to grab more, and we're well below the building height. So we're not trying to be out of character or out of scale with the rest of the neighborhood.
Please.
And I apologize. I'm going to rely on the fact that I'm new to this board and ask this question. But one of the things that makes it non-compliant is the addition of the stormwater planter box, right? That's not allowed within the setback.
The stormwater planter extends past the 4-foot encroachment zone.
Right.
Right.
Okay. Yeah, it's a 6-foot planter box or something.
Yeah, and it's already, in order to catch that water, it already
So
is.
that's part of that's new non-compliance.
That
now.
is, yep.
Okay.
Yep.
All right.
That's, yes. I have a feeling you may be getting more of those in the coming.
Yeah, Brave new world.
That's an issue to be.
So we
dealt with.
tried to keep it, we thought that instead of kind of having it willy-nilly, we tried to make it relate to the house in several different ways and try to keep it as low as we can and stretch it out as long as we can. So it becomes kind of hopefully hidden with things that are tumbling over.
Thank you. Any further questions and discussion? We'll very briefly say that, typically we like to see written petitions as, if you're a frequent visitor of this program, we see written petitions of neighborhood support. But given that this has now been advertised twice, I'm willing to accept your assertion that you met with those 4 neighbors. And I'll see what my colleagues have to say. I would also take the moment to thank staff for reposting those signs. I live not too far from this, and I noticed that the signs were not placed on the right block initially, but staff quickly corrected that, and I am satisfied that there was ample placard notice. Motions from my colleagues or further discussion?
Make a motion.
Mrs. Clark.
I move that the Board of Zoning Appeals adopt the attached proposed resolution approving the use permit requested in case V11953-24-UP-1, subject to the conditions as listed.
Second.
Mr. Chairman,
Ms. Malice.
may I offer an amendment to the motion? I'm looking at the resolution. To state that it's the architectural drawings and plat on page 25 of the staff report.
Yes. Any objection to the amendment? And we will accept that amendment. Any further discussion? I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. Clark.
Aye.
Ms. McCroskey.
Aye.
Chair votes aye. Motion passes 5-0. Congratulations.
Thank you.
I'll just say, if you come back to us with the garage,
Yeah.
Try and get us written support, because it makes our job a lot easier.
Yes, I hear you.
Because you will then be a returning person who knows the process much better.
No, but
Thank you.
it's hard to get. I'm not their mom. So,
Clipboards work well.
But
Thank you.
anyway, thank you very much.
Thank you.
Appreciate it.
Mr. Bowen, can you please call the next case?
Yes, Mr. Kaplan, the next case on the agenda is case number V-11954-24-UP-1. This is a use permit request by Roger Bohr on behalf of Daniel and Rosa Narges Ewell, the owners, to permit a street setback of 11 feet to the building wall, 9.9 feet to the building eaves instead of 25 feet to the building wall, 21 feet to the building eaves as required, and to permit a street setback of 9.7 feet to the deck instead of 21 feet to the deck as required, all from South Edgewood Street, regarding a 2-story addition and deck to an existing 1-family detached dwelling on a corner lot in the R6 zoning district on the premises known as 2800 20th Street South within the Green Valley Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. I do not believe we have any additional speakers who have signed up to speak on this case. Mr. Goldberg, can you confirm?
No additional speakers.
No additional speakers. And then we do have additional supplemental materials that were submitted, and that includes 2 letters of support from neighbors of the property.
Could you state those addresses? Do you have them in front? Could
Sorry,
you
Ms.
state the
Mount.
addresses?
Yes, I believe they are the owners of 1901 and 1915 South Edgewood Street, as well as 2015 South Fillmore Street.
Thank you.
Do my colleagues have questions for staff?
Mr. Kaplan.
Ms. Malice, at least I'm not the only one who doesn't wrong names all the time.
As this, as the Stubb Street potentially provides access to Army Navy Country Club, I wondered if they received a notice.
I can check that for you. And I will also mention that Mr. Rissy authored this report, so he may answer other questions about this, but I'll check the mailed notices we sent out.
Okay, thank you.
Is the applicant with us? Come on down. Would you like to speak to your application?
Just pretty much just want to do the addition. I think I followed through all the what was given to me, did all the neighborhood outreach. Just want to widen my kitchen and dining room so I can age in place. I've been living in the neighborhood since 2002, over 20 years, and just want to beautify my home, and with all the new homes being built in the area. Mine's still the old 1964. It looked like I need to do some tender love and care to it.
Thank you. Do my colleagues have questions for the applicant? No. Discussion, motions. Did I hear Ms. Freshman?
Motion.
Please.
I move the Board of Zoning Appeals approve the attached proposed resolution granting use permit V-11954-24-UP1, subject to conditions in the staff report.
Can I just make a comment? I'm concerned because I think just because this right of way is unlikely to be used anytime in the near future, which I completely agree with, I do think that it's, we have some setbacks and that should be honored to the extent they can. And I may, I may vote against this for that reason, but it's a very difficult one for me because I feel like we should be, maybe there was some way to do this in a way that wasn't gonna go into the setbacks for what's technically a corner lot. So, but that's just me saying, I think we ought to be cautious about just moving in on land because it's not being, moving the setback towards the right of way just because that right of way isn't being used right now.
Can I say something to that? No.
Do you want to hear any more?
I don't mind if you respond.
Go ahead.
Oh, well, as the report stated, you go around that whole entire block, and all the corners within that block is well within, this further close to the curb or the property line than I'm even considering. And the fact that they may use it, like I said, I've been there 20 years, and if you go further, it's a dead end street, and it's almost like a 30 to 40-foot drop into the, down in an RPA area. So if someone wants to come and use that little space or do a right through, I would think that would be, we would talk about something that's, even if the county or anybody would do that, would probably be millions of dollars. Just even considering to put a road hasn't been through there since that neighborhood has been in existence. Yeah. So that's I don't know if Mr. Roger want to add in. That's the gentleman that helped me put together this.
We have an open motion.
So can I ask one more question now? At 2015, was there outreach done to that resident? I didn't see.
Yes, ma'am. Yes, ma'am. I spoke with Miss Costley, I believe.
Okay.
Everybody that I talked to was in agreement. No one had any objection. And these are all long-term neighbors that's been here longer than I have, if not, at least 10, 15, 20 plus years.
Okay. I'll second the motion.
I'm still. Go ahead. You can second it. But I still had Mr. Rissy was following up on Army Navy.
Yes, there was a mailed notification sent to the Army Navy Country Club.
Okay. Thank you.
Okay. So a little out of order there. A motion made by Ms. Freshman, seconded by Ms. Clark. Is there any further discussion? I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. Clark.
Aye.
Ms. McCruskey.
No.
Chair votes aye. Motion passes 4-1. Good luck with your project.
Sir. Thank you.
Mr. Bowen, can you please call the next case?
Yes, Mr. Kaplan. The next case on the agenda is case number V-11955-24-UP-1. This is a use permit request by Michael and Samantha Westfall, the owners, to permit a rear setback of 16 feet to the screen porch, 15 feet to the screen porch eave, instead of 21 feet to the screen porch, 19.5 feet to the screen porch eave as required, regarding a new rear screened porch to an existing one-family detached dwelling in the R10 zoning district on the premises known as 3518 North Ottawa Street within the Williamsburg Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. We do not have any supplemental materials that have been submitted for this case. Mr. Goldberg, I don't believe we have any speakers who signed up.
No additional speakers for this case.
Okay, thank you.
Thank you. Do my colleagues have questions for staff on this application?
I have a question or a comment, perhaps. It seems to me when I was reading through the report that there were letters of support, I believe, all of which, and the addresses were all blocked out. And I understand about FOIA and all that, but it's very unhelpful if either the applicant or the staff does not perhaps provide a summary or a list, an anodyne list of what the feedback is, because as everyone has already heard, neighborhood feedback is absolutely required. So it might be helpful if the staff can't do it, if applicant can at least tell us which dwellings on the tax map you have support from, because that will certainly make a difference for me. Thank you.
Mr. Goldberg, can you bring up the tax map?
Good evening. My name is Michael. Hi. The letters of support were emails that were written. I think what was blacked out was the email addresses. I submitted everything to the team. I think the team may have done that for the Freedom of Information.
Yeah, that's correct. We redacted the email addresses, not the street addresses.
So there were no street
There were no street addresses, and that's the problem.
Yeah.
So sometimes we can match up names based on property records, and then that would be based on email addresses. But
It's
we
too much research.
have no ability, so we don't know who those emails were from.
Sure.
So
And it was in the, actually labeled the file name was the address. So when it gets printed and put in the packet, I
and
understand.
we didn't get that.
Yeah.
So if you could just
I'm
run through them pretty quickly.
happy to walk through. Yep.
Yep.
So 3512 North Ottawa is Matt Lehman. I should look at the page numbers here. Huh? Let's see. If I go to the first letter of support in the email, 3512 is Matt Lehman. The second page of the email actually is not an adjoining property. It's across the street. That's Bob Ruggiero at 3513. Third letter of support is for 3519. This initial email that's included in the packet right now, I had not yet received written feedback from my neighbor. He and I have spoken, and I do now have 6 copies of an email from him saying he supports the project. So that would be the 5th letter of support from the neighbors.
Sorry, what was the address?
That's 3519 North Ottawa. That's the address that was mentioned in the report that had not acknowledged yet, but I do have that acknowledgement now. The next page in the packet is Christopher Scully. That address is 6128 36th Street North, the property behind. And the final letter that's included in the packet is Uday Ragati, and that's 6134 35th Street North.
Thank you.
I have these additional packets.
Did you want to speak to your application further?
Grateful for the opportunity to request this use permit. We wish to add a modest 14 by 16 foot screened in porch to our backyard. I saw the image that came up. It would kind of fit over the stone patio right now, but not the entirety of the stone patio. The stone patio will go away. And we've got unanimous support from our neighbors who are supportive of our desire to do this.
Thank you. Do my colleagues have questions for this applicant?
Would have been a lot easier if we had the addresses. We'd have expedited you.
Might have been expedited, right?
Because you did do good neighborhood outreach.
Yes.
Motion?
Ms. Freshman?
Are you prepared to make a motion?
Yes, Ms. Freshman.
I move the Board of Zoning Appeals approve the attached proposed resolution granting use permit V-11955-24-UP1, subject to the conditions in the staff report.
Second.
A motion made by Ms. Freshman, seconded by Ms. Malice. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. McCruskey?
Aye.
Chair votes aye. Motion to pass this use permit passes 5-0. Good luck.
Thank you. Thank you.
Mr. Bowen, can you please call the next case?
Yes, Mr. Kaplan, the next case on the agenda is case number V-11956-24-UP-1. This is a use permit request by Mark Woods Construction Services on behalf of Kevin and Elizabeth Jones, the owners, to permit a right side setback of 7.8 feet to the building wall, 6.8 feet to the building and porch eaves, and 8 feet to the porch instead of 25 feet to the building wall and porch, 21 feet to the building eave and porch eaves as required, regarding a rear addition and porch to an existing one-family detached dwelling on a pipe stem lot in the R8 zoning district on the premises known as 2929 North Lexington Street within the Williamsburg Civic Association. Staff recommends that the board adopt the attached resolution denying the use permit request. Staff has also provided the BZA with 2 alternative resolutions in case the BZA sees fit to approve the subject use permit request as advertised with conditions or with a minimum right side setback of 9.6 feet to the building wall with conditions. Please note, we do also have supplemental material for this case, which includes an email acknowledging support from a neighbor. And Mr. Goldberg, I don't believe we have any speaker slips for this case.
That is correct.
Thank you.
Thank you. Do my colleagues have questions for staff on this item?
Mr. Kaplan.
Ms. Malice?
So the alternate resolution number 2 with the right side setback of 9.6 is included in our package. And that number comes from the analysis?
That's correct. 9.6 feet was the closest building wall we could find from a side lot line on a pipe stem lot.
Thank you.
Mm-hmm.
And that's from a pipe stem?
Correct.
Thank you. Is the applicant with us? Would you like to speak to your application?
I would, thank you. I've been a resident of Arlington for 60 years, since the day I was born. We've been in 5 different homes in Arlington, 3 with my wife, Beth. We built the home that we're in right now 33 years ago and feel very fortunate to be a part of the Arlington community. When we built our first home, when we built this home originally, we had to come through the variance process when the rules at that time required measurement of the height of the house from the curb to the tip of the house. And so we've been through this process for before. And when we set out to do this addition off of our family room, we did not want to go down that road again. It was never our intent to present a plan to the county that would need to be rejected. We wanted to stay within the lines. Our architect is here with us tonight, Lucy Adams. She can speak to some of the specifics if we need to, but we believed that we were presenting plans to the county that stayed within the lines, so to speak. As the rule 33 years ago for the height, we've learned that there are some rules unique to pipe stem lots. Those pipe stem lot issues or regulations didn't exist when we built our house originally. So reflecting back on building our house 33 years ago, our original plan, we bought plans from a builder that would allow us to put this same room on, but we were young and couldn't afford to do that at the time. So that's what we're seeking to do right now. When we submitted the plans and we got the rejection, we were hoping to avoid scrapping and starting all over, which is why we're here with you tonight. We want to thank the staff, BZA staff, and Mr. Bowen for taking the time with us to walk through the explanation of staff and really speak to the issues, one of which, of course, is the fact that we're considered to be on a pipe stem lot. Our proposed 7.8 foot setback is just to a 6 foot section of wall, a very minor encroachment. This compares favorably to the pipe stem comp at 2804 North Harrison Street with a side setback of 6.3 feet to the porch eaves. The staff report suggests that there are minimal comps for what we're looking for on pipe stem lots and suggests that our lot looks and acts more like an interior lot rather than a traditional pipe stem. As such, staff provided us with comps for interior lots in the surrounding area. These comps show setbacks ranging from 3.3 feet to 7.5 feet, all more notable exceptions than the relief that we're asking for tonight. Staff also notes in their report that the main footprint of our home would remain notably smaller than those of surrounding properties. Staff also notes that the replacement of existing structures minimizes the impacts to other portions of the site that are not currently developed, and that our property does not feature any champion, significant, or notable trees. For these reasons, the project, quote unquote, may be seen as helping to preserve the natural landform, historical features, and or significant trees and foliage on the site. Staff has not identified any adverse impacts to neighbors or any tangible detriments to the public welfare, nor any tangible injury to property or improvements that can be attributed to construction. And we do have unanimous neighbor support, which we did visit and we did present, and we do have the petition signed by everybody. There was one neighbor who was out of town when we did the outreach. I finally was able to get together with her Monday of this week. We provided an email communication. She is an attorney and has suggested that she would not be able to sign the petition that we had initially created, but that she would be happy to take a phone call from staff confirming her support of our project. So we provided that information to Mr. Bowen, which hopefully has been forwarded on to you all. So with all that said, staff seemed to, I believe that the recommendation against right now was one that by creating and giving us two alternatives leads us to believe that it's not a major exception that we're asking for. And we hope that you all will also see the reasonableness in our request. So we thank you.
Thank you. Do my colleagues have questions for this applicant?
Mr. Chairman.
Ms. Malice.
And maybe could you put up the tax map just so there's a property behind you that looks like it's built on two lots. That's the same ownership for both lots, I assume.
There are several very large, let's see. Okay,
see that one right there? That I assume that's all one property owned by.
Yes, that's the McCabe's, and they have signed our petition of support.
Yeah, so you see that they actually have two lots. And
yes.
Okay. And the house just below you on the street, is that the one that the attorney?
That's the attorney, yes.
That's the attorney, okay.
Any further questions or discussion?
Mr. Chair, I have a question. Was there some consideration for the alternative recommendation, 9.6 feet?
Well, we felt like we were submitting our initial application based on full compliance initially. In fact, as we were preparing the plans, we got some guidance from folks suggesting that it was okay, and then we got guidance from others saying it wasn't okay. And when we submitted it for permit, we thought we were in compliance, complete compliance. So we appreciate staff having presented the alternatives, but we're hoping that the modification we're asking for, the exception that we're asking for being minor, and our lot being treated or being considered as a more similar to an interior lot than a pipe stem lot, and the fact that we have even the neighbor support of the one property line that this impacts. We're in it. If you look at the plat, you'll see there's a lot of space there. There's really only one neighbor who could potentially even see this 1.5 feet extra to the structure, and that's covered by a bush line completely. There's no direct impact on anybody at this stage. So we're hoping you'll consider the application as is.
Can you explain, or I don't know if it was staff that suggested that, what you mean by it's more similar to an interior lot than a pipe stem? Was that something you
or it says in the report,
Oh, in the staff report?
There's yeah, I don't remember the exact verbiage.
Yeah, I can shed a little bit of light on that. The zoning ordinance distinguishes between corner lots and interior lots, and the definition of an interior lot is simply any lot that is not a corner lot. So it's pretty broad. So pipe stem lots they are interior lot. This is an interior lot, but it is a subtype of an interior.
But you're not saying, I'm sorry, so you're not saying it's not a pipe stem lot, but you're
Yes.
saying it's not okay.
Because it's a pipe stem lot, so we provided analysis based on other pipe stem lots, but then we also provide analysis based on other interior lots that were not pipe stem lots, since it is technically both an interior lot and a pipe stem lot.
Any further questions or discussion while I'm looking at this map?
Mr. Chairman,
Ms. Malice.
I am generally not one to push to create new precedent in terms of, further reducing the setback that will be used for future comparisons. But I think in this case, I am persuaded by the general idea that this is an interior lot. While it technically is a pipe stem, I guess I think it's sufficiently compatible with other interior lots that this could be approved as asked for.
And I will say that it's a difficult one for me. Again, I have a concern because it is a pipe stem lot, and the pipe stem lots currently are, the rules, and I know this has changed since you all built your house, but they now are set to create big setbacks all the way around them. So I have a concern that we're creating an exception to that, but it's a close call, I think.
Yeah, I agree.
Yeah, I'm going to mirror both of my colleagues. This is a close call that I'm looking at. And in fact, I find myself calculating what that number of amount that makes this a pipe stem is, which I'm going to estimate to be about 22 feet-ish. This is a close one. If this were a new build, raise it in new build, I think this would probably be a different discussion. But I don't know. So I'm going to think about this while my colleagues decide who wants to make a motion.
I would support it as advertised.
Would you like to make a motion to that effect?
Okay. I don't know if I have the right language, but I can do that.
Ms. Freshman, the motion should be on screen if your monitor's turned on.
Oh, okay. In case of V-11956-24-UP1, I move that the Board of Zoning Appeals approve the alternative resolution number 1, which is approval as advertised with all the conditions.
Thank you, Ms. Freshman. Is there a second?
I'll second.
A motion made by Ms. Freshman and seconded by Ms. Clark. Is there any further discussion? I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. Clark.
Aye.
Ms. McCroskey.
No.
Chair votes no. Passes 3-2. Thank you.
Thank you.
Mr. Bowen, can you please call the next case?
Yes, Mr. Kaplan. Next case on the agenda is case number V-11957-24-UP-1, a use permit request by TCS Building Incorporated on behalf of Gregory and Aaron Nietzsche, the owners, to permit a street setback of 22 feet to the building wall instead of 25 feet to the building wall as required from 18th Street North regarding the enclosure of an existing carport to an existing one-family detached dwelling on a corner lot in the R8 zoning district on the premises known as 1824 North Inglewood Street within the Terra Leeway Heights Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. We have not received any supplemental materials for this case, and Mr. Goldberg can confirm I do not believe we have any speaker slips either.
Yeah, no additional speakers.
Thank you.
Thank you, Mr. Bowen. Any questions for staff? The applicant is approaching. Would you like to speak to your application?
Yes, thank you. Good evening. Yeah, so essentially we'd like to enclose our existing carport and to create some additional interior living space. We have 5 kids, so we can use all the living space we could have. The enclosure won't cause our house to be any closer to the property line than exists now. The footprint of the carport area and the roof will also be unchanged. And then, excuse me, the materials that we'll be using will be consistent with the rest of the home and complement everything that exists currently. And then lastly, we're going to be removing the existing front driveway, which will reduce the amount of impermeable area by over 300 square feet.
Thank you. Any questions for this applicant?
I have a question.
Ms.
You had several letters of support from your neighbors,
We did, yep.
but the 2 neighbors across the street who actually are looking at and closest to that, I didn't see anything from 5445 or 5444 Inglewood. So do you know if you have?
Excuse me.
I'm Erin Nitchie. We were given certain addresses to get signatures for. So I know that the people kind of on the corner look at it, but we weren't given that address, so I didn't get their signature.
Who gave you those addresses?
Probably
Our-
John.
Yeah, John,
our
architect.
The architect.
Gave us the.
That's not from us.
That's, yeah, because our requirements are completely around the site. And in
Right.
this case, those 2 neighbors on the 2 corners actually face your carport.
Well, it's just the one. We got the other corners.
I don't
There's
see
only
that.
I don't have that. I didn't see
Have
from
the,
those 2.
Do you have the list?
Yeah, I was.
Mr. Goldberg, can you bring up that map, please?
You have the map, because I know which one. Yeah, so we've had directly across to the left. It's the people diagonally that we did not get, right?
You don't have the ones across.
And straight
either.
across.
1830, is it 1830?
You have 5444 19th Street.
Yep.
That's 18th Street, 18th Road.
No, we got them. And they might have written down their address wrong, maybe. It was Nancy and Bert, right?
They wrote their
let
address
me-
wrong.
Four, 19.
They wrote down 19th Street.
Mm-hmm.
I can't imagine we got anyone on 19th Street, but, oh, she put 19th, but they're 18th. That's Nancy. I didn't
She
double
made a
check.
mistake.
She made a
Yeah.
mistake. She is the one directly across from us.
That 1830
Mhm.
house.
They're 5444, 18th.
That's unusual.
She wrote that, I had her write her address and she wrote it wrong. I know it's,
So 5444
is there a way to look
is
up her name?
18th Road on the corner,
Mhm.
and you have that one? And what about across the street,
I
5445?
wrote down 19th Street and her address is 18th Road.
Yep. I don't know what to say. Yep. She did. I'm sorry. And then who else were you asking for?
The one across from that, diagonal from you, 5445, which I guess is also 18th Road?
Yeah, but we did not get them. They're the ones diagonal. That's not shown in that.
We're talking about enclosing an open carport that visibly right now is more of an eyesore than what we're gonna put nice windows and it's gonna look a lot nicer, quite honestly, in removing the driveway.
I would just make the comment that while I think it's a benign project and probably an improvement to eliminate a driveway, I think relying on your contractor for rules of the road can be very precarious
Good advice.
in terms of feedback, because we've had several cases already that were deferred because the feedback was inadequate, and you don't want that.
Yeah.
Any
Just
further
give-
discussion, Ms. Malice?
Just give me a minute.
Ms. Malice is looking up something that I suspect I know what.
Is there?
Oh, I. There's maybe something wrong with the tag. This is not showing any response for 544 North 18th Road. Is
Because, yeah, the front of their house,
on
ours is Inglewood, theirs is 18th.
Yeah, you've
Yeah,
got
it faces differently.
you've got the number for 18th Road, but
Mhm.
it's not coming up with a
It's not.
no. So this it may be something wrong with the tax map. 18th Road North. That's very curious. I can try Inglewood.
Yeah, because the front of their house fronts 18th Road.
Doubt that's going to come up.
Are you looking at 5445?
I was looking at 5444, the one that wrote their address wrong.
Mhm.
Which has a driveway on Inglewood, which makes no sense.
Right. Inglewood.
Mr. Kaplan, is there any assistance
Oh.
I can offer by perhaps chance checking real estate assessment records for property ownership or mailed notices that we sent out?
Yeah, why don't you check the notice?
They all got the notices. I know they did.
The mailed notices, and for which properties in particular, Ms. Malice?
5444 North 18th Road.
And 45.
And then same.
18th Road North. Yeah.
The two corners.
544 19th Street North got a notice.
Well,
And
then maybe that's correct. I don't know.
But that's not where they.
It may change.
but
That
they-
street may actually
might,
change
because
over that
She
intersection.
wrote it down, so I'm not.
I think it does. I think that 18th Road
Becomes
begins
19th.
right there.
No, yeah.
It becomes 19.
I believe you're correct in my own reading of the staff map. That was my impression as well. And then, yeah, 5445 19th Street
It's-
North.
And that's like and then it
Also
moves
received.
over further down as it goes into the.
That makes a lot
what-
more sense
I
than
think it
somebody writing
changes.
their own
I think
address
the,
now.
the name of the street changes as it goes
You
through
have
that intersection.
5445?
Okay.
Got it.
And 5445, yes, also received the mailed notice.
Okay.
5445 19th Street North, just because we're discussing the street names.
So we did not get their signature. They're the people dying.
I think you should be cross with your architect. If you're relying on him to read the rules.
And I would also.
They're all new at this, yeah.
When you applied for the use permit on the County Permit Arlington site, and Mr. Bowen can chime in if I'm incorrect, you should have received a letter or a kind of a packet explaining, what is required and what is expected from you. And in those materials is a tax map with X's that go around the applicant's house showing what this board typically would require. I say it to all the applicants in this position is the county board has required us to take into account compatibility with the surrounding neighborhood. And the primary method for this board to make a finding for the compatibility of your project in the neighborhood is neighborhood outreach, right? Because that's a major factor that we like to consider. And it also, frankly, helps prevent any future issues. You go and do this project, and then one of the neighbors comes out really angry, yelling and screaming. And so we'd like to get all of this stuff addressed beforehand, and again, helps us do compatibility. So that being said, I will defer to my colleagues in how they'd like to proceed on this one. Colleagues? Yes.
I can support it.
Mr. Chairman, I'll make a motion.
Ms. Malice.
Give me a sec to find it again. I move that the Board of Zoning Appeals approve the attached proposed resolution in the use permit case V-11957-24-UP-1, subject to the conditions listed.
Second.
The motion made by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion? Ms.
Yeah, if
McCroskey?
I can just make a comment. This is my night to be very grumpy about these things. It bothers me a little bit that I will support it because of the mild extent of the setback incursion, but it does bother me that we're taking an open structure, for which I believe the setbacks are different. And Blake, you can tell me if I'm wrong about this, and approving it to be enclosed. It just strikes me as sort of that creep of we approve a screened porch, which is allowed because it's a screened porch. And then the next step is to come in and enclose it. And the setbacks are different for the two types of enclosed and unenclosed structures. And again, you can tell me if I'm wrong. I think I will nonetheless support this because it's only a 3-foot difference from the 25 to the 22 feet. But I did want to just make that point. So I can be grumpy on every project tonight.
Ms. McCroskey, I will note that the carports would have the same setback requirements of building wall.
Oh,
They don't
okay.
get an encroachment allowance.
Okay. Okay, so really this is sort of an existing one that,
Yeah, new construction on an existing
okay, thank you.
non-conforming feature.
I also just want to state for the record that the BZA's assistant, Ms. Petrosini, was also confused by the issue on the 5444 18th Road and 5445 18th Road as well. And she had emailed the applicants with those addresses as well. So this might not all just be the applicant's fault. It is, they also might have gotten poor, I don't want to say poor, but those addresses. So this it's just a kind of unique circumstance with this location. That said, I'll call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. Clark.
Aye.
Ms. McCroskey.
Aye.
Chair votes aye. Motion for this use permit passes 5-0.
Thank you.
Thanks. Mr. Bowen, next case, please.
Yes, Mr. Kaplan. Next case on the agenda is case number V-11958-24-UP-5. This is a use permit request by Cook Brothers on behalf of Gerald Woodruff, the owner, to permit a street setback of 17 feet to the building wall and deck, 16.5 feet to the building eaves, instead of 25 feet to the building wall, 21 feet to the deck and building eaves as required, all from South Ives Street, regarding a building addition and deck addition to an existing one-family detached dwelling on a corner lot in the R5 zoning district on the premises known as 839 20th Street South, within the Aurora Highlands Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. Please note that we do have additional piece of supplemental material that came in for this case, which is a BZA comment form in support of the project. And then I will also once again confirm with Mr. Goldberg that we do not have any speakers for this case.
Correct. No additional speakers.
Thank you, Mr. Goldberg.
Thank you. Questions for staff on this application?
Mr. Bowen, what was the address for the additional neighborhood outreach?
That was 915 19th Street South.
Is the applicant with us? on down. Would you like to speak to your application? We do not require people to speak to their applications.
We have questions.
You might be called down for questions. Are there questions for the applicant?
Yes.
Well, there are several missing neighbors, so someone should respond to that.
Are you talking about 833?
Could you identify yourself, please?
I'm Gerald Woodruff's husband, Tony Saba. So which neighbors are you? Because we had a lot of them that signed. Are you saying 833?
Across, directly across on Ives, on the corner of Ives and 20th Street, and 833 next door. I didn't have.
33 next door is currently vacant. He was our longtime neighbor for over 20 years and he passed away. Yeah. And it's been sold and they are renovating inside. So it's vacant.
What about across across Ives, directly across and diagonally?
We have those. We have the is it 838 and 836?
836.
Let me see. 834, 834, 834.
It's 900 20th Street. And,
Oh,
and
900.
And the vacant lot across from you maybe is owned by somebody else.
The vacant lot is a park. It's the new Ives Park that the county created. Yeah.
Okay.
So 900 20th Street, 836 20th Street.
836.
And
he came to the house to sign it, Gerald. Where is it? You couldn't go up the stairs. 834?
No, 836.
834, 834. Yeah, that's the duplex. Oh, the renters. I can't see those two. 838, oops. Yeah, you have 838.
yes, you don't have 836 and 900.
6. Yeah, 836 is. Yeah, 838.
Yeah, Cauldron's 834.
Next to 838, I don't see it. So we went to everyone that answered the door, everybody around. The duplex 836, apparently we don't have that signature. So we have the one right next to it.
900.
That 900, we don't even know. They're never there. The diagonal. The diagonal straight across. What, didn't James live there with his parrot and then he sold it and then we never see those neighbors? Well, this is all that we have. We have a lot of signatures and whatever's here is here. Gerald went with his walker to all that he could go and some of those places are not accessible.
So
for him to go and knock on the door.
You went to places that you didn't need to go. When there's an application that shows exactly, in the application, there's a document that shows exactly which neighbors that you need to contact.
Mm-hmm.
The rest don't, people that live on 19th Street on the other side aren't relevant and weren't necessary to contact.
Alice. So I guess we're discussing with the board. Does
One thing that I'd like to have on the record, and this has to do with people's signature. We got an email from the county saying that an address was invalid, and that's Tom Burton on 839 South 19th Street. He was very shaky when he signed it, and that is in fact a valid signature, even though maybe it wasn't required. He's been a longtime neighbor of ours. We continually switch our mail because they're 839 19th and we're 839 20th. And he passed away a week after he signed it. So this is one of the last things he signed and supported us. And we liked it to reflect that, and not that his address was invalid. That's all.
Ms. Mills?
Would that have been from Miss Petrosini? I doubt that she would have said it.
I don't think that was, yeah.
She would have said it was invalid. It's perhaps she could not read it. But you did get Miss Petrosini would have sent you an email specifying which of these addresses were missing.
The only email we had was from that address was invalid, that 839 19th Street. Maybe it was hard to read. It kind of looks like a 14.
We have
839.
Yeah,
839 20th Street is us. 839 19th Street is Tom, our neighbor that passed away.
May I chime in quickly? We're receiving some comments that it's hard to hear the hearing. So I'd encourage both the BZA members and our applicants and speakers to speak more closely to the microphone.
Thank you.
Yeah, that's the only email we received, that the 839 South 19th Street is not a valid address, and it is.
That wouldn't be an address that would be of concern to us, 19th Street, other than the ones that are right behind your property, which you have.
Right, but I just wanted to be on the record that this is a valid address, and our friend Tom Burton signed it, and he passed away a week after he signed it.
Okay.
Mr. Kaplan, as with the last case, if I can offer any assistance by speaking to the mailed notices we sent, please let me know if there are addresses you'd like me to look at.
Thank you. Ms. Petrosini informed me that she had Cook Brothers email, not the applicant's email, when she was corresponding. That she had the Cook Brothers email and not the applicant's email when corresponding regarding outreach.
Well, that's who she should have been.
They were the agent, correct?
Your agent received an email showing which addresses were missing.
What is this board's pleasure tonight? Ms. Clark, were you going to say something?
Well, I was going to, if Ms. Petrosini confirmed.
In your microphone.
If Ms. Petrosini confirmed that these two addresses were mailed notices, the 900 and the 836?
I think Mr. Bowen would confirm that they were mailed notices.
Okay, but she was sent notice to the Cook Brothers about those two addresses?
Yes,
okay.
She will confirm that shortly.
Did you get those?
Yes, so confirmed. What would my colleagues like to suggest?
Do we have Cook here?
Yes. He's in the front row.
Can you speak to whether or not you were contacted about the missing addresses?
I did not receive any emails from any neighbors.
Can you
directly-
identify yourself, please?
Directly to Cook Brothers. I've corresponded with the owner.
Would you identify yourself for the
I'm
record,
sorry.
please?
Yes, Steve Tinter. I'm the general manager of Cook Brothers.
Miss Petrosini has informed me that she requested from the Cook Brothers agent 833 and 920th.
833,
833 and 920th.
because it's 836.
Not the 836.
Is the one we're
No,
missing.
833 is the next door neighbor.
833 is the neighbor that passed away in Christmas and the house is vacant.
But it has an owner. And our rules say that you're to contact the owner.
I think they have that one from the owner who signed it.
833?
833.
Yeah, 833 is
It
vacant.
didn't have I guess
833
it
is the
must
one
have.
where it said they died and they don't have, that's the next door neighbor.
Right.
They don't have that.
I thought they said that they had that and he passed away.
No, they're talking about on a different street.
There's two.
Sorry.
There's.
Yeah. Oh, you're right.
Yeah.
You're right. Sorry.
There's one who passed away right after Christmas. and
Right.
one-
Yep. So, decision time.
This is basically to age in place.
We
because my-
I'm
yeah.
sure. Thank you. We understand. So I think the decision before the board is whether we feel we have enough to meet the compatibility with the neighborhood test based on the record before us. I'm sorry, Ms. McCroskey, were you going to speak? I cut you off.
I was just going to say that because of the nature of the addition and the fact that it doesn't sort of go past where the existing nonconformities are, I would be prepared to support it because there's a good number of the neighbors who have weighed in.
Would anyone else like to speak before I entertain a motion?
You know, I don't believe I'm going to support this. Just on the issue of neighborhood outreach, I would have gone for a deferral.
Would either of you two would like to make a motion?
I'll try. I move that the Board of Zoning Appeals adopt the attached proposed resolution approving the use permit V1195824 UP5, subject to the conditions listed in the staff report.
I'll second.
A motion made by Ms. McCroskey, seconded by Ms. Clark. Is there any further discussion? I will call the roll. Ms. Malice?
No.
Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. McCroskey?
Aye.
Chair votes no. Motion to passes by 3-2. Thank you and good luck.
Thank you.
Mr. Bowen, what's the next case on our agenda? Oh,
Uh,
the variance.
The
Can you please
next
call-
case is the variance
Can you please
request.
call that?
Yes. The next case on the agenda is case number V-11959-24-VA-1. This is a variance request by Mike Brennan on behalf of Richard and Ellen Murray. The owners to permit a minimum distance between buildings of 10 feet instead of 20 feet as required for a multiple family residential development with multiple main buildings regarding interior structural alteration to an existing non-conforming multiple family residential building, including an interior renovation to remove a load-bearing kitchen wall and an attic renovation in the RA 1426 zoning district on the premises known as 3414 South Stafford Street within the Fairlington Civic Association. Staff recommends that the board adopt the attached proposed resolution approving the variance request with conditions. We have no supplemental materials that have been submitted for this case. And Mr. Goldberg, I'll once again ask that if we have any speakers who have signed up.
No additional speakers for this case.
Thank you.
Any questions for staff on this variance request? Is a common issue before this board. Is the applicant with us? Yes, he's in front of me. Would you like to speak to your application?
It's the same thing that's been approved multiple times in Fairlington, all interior work, not doing anything outside. It's just basic structural work to your home. So it's pretty standard stuff.
Thank you. Any questions for this applicant?
Motion?
Motion, Ms. Freshman.
I move the Board of Zoning Appeals approve the attached proposed resolution granting variance 11959-24-VA1, subject to the conditions in the staff report.
Thank you, Ms. Freshman. Is there a second?
I'll second.
A motion made by Ms. Malice, seconded, a motion made by Ms. Freshman, seconded by Ms. Clark. Is there any further discussion? Hearing none, Ms. McCroskey?
Yeah, I'll just state on the record, this is something we see regularly. The issue is there's absolutely nothing about the proposed project that's going to affect the distance between the buildings. However, due to the current state of the zoning ordinance, we have to approve it as a variance. So even though it doesn't quite meet all the standards, I will support it. And I think others are in the same boat.
Thank you. Any further discussion? I will call the roll. Ms. Malice? Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. McCroskey?
Aye.
Chair votes no. Motion on this variance passes 3-2. Good luck with your structural work.
Great, thank you.
Yeah, I have been requested to take a very quick potty break. So we're going to recess for 5 minutes or so. Sorry, I have 2 kids, so it's. Can you, how many speakers do we have signed up for this item?
Currently, we have 4 speakers signed up.
Okay, we have 4 speakers. So if anyone else is signing up, this is your time. Before we start, I just want to give a quick reminder that when hearing appeals, this board only has the power to address whether the zoning administrator was correct in their determination of a specific order or determination presented by the parties before us. In this case, the granting of an EHO permit. As such, this board does not have the power to change or alter the underlying zoning ordinance, the processes or procedures for those determinations, or policy. The powers of this board regarding appeals are set out by the Commonwealth of Virginia, and this board's inquiry tonight is limited to the specific determinations made in the EHO permit that have been appealed by this appellant. With that being said, can whoever's calling the case call the case?
Yes, Mr. Kaplan. The next case on the agenda is case number V-11960-24-APP-1. This is an appeal request by John Pomeroy of the Zoning Administrator's decision to approve expanded housing permit ZEHO 23-00061 for a lot located in the R10 zoning district on the premises known as 2400 North Lincoln Street, RPC number 04024001 within the Dover Crystal Woodmont Civic Association. Staff recommends that the board adopt the attached proposed resolution affirming the zoning administrator's decision. We do have supplemental materials for this case. This includes an email from the appellant dated 6/8, which includes elevations and a site plan of the proposed EHO development. We have 3 attachments related to a submitted FOIA request. We have a comment and response letter related to the LDA permit for the subject property. And we have BZA comments forms from 4 speakers in opposition to the issuance of the permit. And we also have 4 speakers who have signed up to speak on this case, as well as a speaker slip from the EHO permit holder's attorney, who is also authorized to speak through the consent statement.
Thank you, Mr. Bowen. I think this board's process has typically been to call the parties up, have them take their 20 minutes apiece, hear from speakers, and then we will address questions to the parties as this board then will choose afterwards. Why don't the county and the appellant introduce who will be speaking for them, and then we'll get started.
Evening, Arlo Bavam, zoning administrator. For the record, I have a very brief statement. I'm joined by Ann Golsky of the county attorney's office. I believe the property owner and his attorney may be addressing the board or answering questions, but we're happy to share our 20-minute allotment of time with those folks.
Thank you.
Sure.
Yep. And who will be representing the appellant tonight?
Yeah, John Pomeroy.
Thank you.
I have a PowerPoint presentation to run through.
Excellent. Ms. Vaughn, are you starting?
Sure.
Please.
So the appeal before you is of an expanded housing options permit issued pursuant to the Arlington County zoning ordinance on January 29th, 2024 to permit a 3-unit townhouse project on the subject property. The appellant contends that the permit was issued in error and should be revoked. The staff report provided addresses the appellant's arguments and the county's response in greater detail, but to summarize them briefly here, I'll reinforce that staff believes the subject expanded housing options development permit was issued appropriately because the proposal is compliant with all relevant requirements, and standards found in the Arlington County zoning ordinance. While many of the appellant's arguments address policy and process concerns, one feature of the proposal that was raised in a number of different contexts is the trash bin concrete pads. The only relevant expanded housing options development or other standard in the zoning ordinance that addresses this is found in subsection 10.4.6.g.2, which requires screening of trash collection and storage areas from the street. All aspects of all proposed locations for trash bin concrete pads meet zoning ordinance standards and requirements. The appellant notes a discrepancy in the location of one trash bin pad for one of the 3 townhouse lots between the landscape plan and the site plan, and believes this discrepancy should have been grounds to deny the expanded housing options development permit. In this case, the landscape plan is provided to ensure that that permit applicants demonstrate compliance with landscaping requirements, which do not include standards for the placement of trash bins, but instead address required trees, which may either be existing trees maintained on site or those that are planted. Site plans, on the other hand, are used to indicate the location and placement of structures, among other things. So in the event of a discrepancy between the 2 drawings, I would agree in this case with the attorney for the property owner that the site plan location controls, but I'd also note that both proposed locations are approvable, and such discrepancies are typically resolved at the permitting stage where actual construction is being proposed and authorized. Finally, the appellant's statements address a number of concerns, many of which are not relevant to the zoning ordinance, my authority as zoning administrator, or the specific characteristics of this expanded housing options development permit. With regard to all of the arguments and issues raised that are beyond the scope of the zoning decision being appealed, staff believes the BZA lacks jurisdiction and authority to address them. And in closing, staff recommends that the BZA adopt the proposed resolution affirming the zoning administrator decision to improve the EHO development permit number ZEHO 23-00061.
Thank you. Ms. Golsky. You were on.
It did.
It did.
It turns red.
Yep, you're good.
There you go.
I don't have anything to add unless I can answer questions.
Thank you. And were you ceding your time to the homeowner?
Correct.
Is the homeowner or his applicant, or is his agent with us? And can you state your name when you?
Well, good evening, Mr. Chair, members of the Board of Zoning Appeals. My name is Matt Roberts. I'm an attorney with the Herschel Law Firm here tonight on behalf of the owner and the permit holder.
Hold the microphone closer.
Which is a related entity. We appreciate the opportunity to be here tonight and to respond to some of the matters raised by Mr. Pomeroy in his appeal. I will say that we filed our response to this appeal on June 3rd, so I will be as brief as possible this evening. In short, we believe that Mr. Pomeroy has not demonstrated standing to bring this appeal, and the BZA can dismiss on that basis. Further, we concur with the zoning administrator that the appeal lacks merit, and the zoning administrator's decision to issue the EHO permit should be upheld. So as shown in the response of June 3rd that we filed, and that is in your packet this evening, we do believe Mr. Pomeroy lacks standing. Standing is a very basic prerequisite for the BZA to act in its quasi-judicial role in this appeal. So both under the state statute and the zoning ordinance, the only people who may appeal, who are not the property owners themselves, are those folks who are aggrieved by the zoning administrator's action. That's a very clear formula under Virginia case law. So if you're not the owner, you must live in close proximity to the subject property. And further, you need to allege facts, and this is a quote, facts demonstrating a particularized harm that is different from that suffered by the public generally. So it is not just simply some alleged harm out there in the ether. It is something that harms your interests personally. And as we demonstrate in the response, there is no alleged particularized harm, let alone any harm that might be said to be suffered by the public in the issuance of the CHO permit. As staff rightly points out, the appeal can be sort of summarized in three different categories as to the bin pads, townhouse location and size, as well as a balcony on what I'll call Townhouse C. As to the bin pads, Mr. Pomeroy states that there's a discrepancy on the landscape plan and the project site plan. As already has been pointed out by the zoning administrator, the site plan is controlling here, but the landscape plan simply doesn't deal in that element. But it's important to point out that Mr. Pomeroy's appeal does not show anything that would discern why he is harmed by the location of the bin pad. We'll concede that it does say it will be an eyesore, but in that sense, he also admits that it will be screened per the EHO requirements. And further to that, there's simply no reason to believe that Mr. Pomeroy is particularly harmed by a proposed eyesore of the trash bins as opposed to something the public at large might simply suffer. Again, even if you assume this is a harm, it's not a particularized harm. Second, as to townhouse location and size, he states that this is going to be closer to his property line and also indicates a desire to have preserved the house that was there at the time of the sale. But again, no allegations that we can find or that you will find in the appeal stating how those issues affect him or his personal interests or otherwise. I would point out that there is no mechanism in the zoning ordinance or Virginia law more generally that would allow neighbors to comment upon the aesthetics or desirability of something that is otherwise a by right permit issuance in the county. That is, if you check all the boxes under Virginia law, the permit must be issued. It is not discretionary. And so in that sense, simple dissatisfaction with future aesthetics is just simply not enough. And last but not least, he talks at some length about the balcony on Townhouse Unit C. He raises a number of issues with that, but I think if we were to focus on one in particular, he talks about the loss of property value. Under Virginia law, alleging property value loss just in general is simply not enough to gain standing. That is simply too speculative. I believe tonight you're likely to hear more about a tax appeal that Mr. Pomeroy filed and that appears to have been finalized. I will say that in general, Virginia law would not allow tax assessments as a demonstration of value or value lost. In the eminent domain context, that is absolutely clear. More to the point, if you look on the county's website, it tells you the factors that tax appeals take into account, which really have nothing to do with permits issued next door to you, has much to do with sales that are comparable in the neighborhood and otherwise. Even if the BZA were to find standing, we would also agree with the zoning administrator that there's just no showing or even an allegation of how her decision to issue the EHO permit was incorrect in any way, shape, or form. So as the BZA knows, and as was stated this evening at some length and multiple times, the purview of the BZA tonight on this appeal is whether the decision of the zoning administrator was correct or not. We are not permitted and we should not be looking at issues outside of that window. Mr. Pomeroy raises a number of such issues, due process violations, a supposed taking, as well as bringing in the ongoing EHO litigation that remains pending. I would just simply state none of those are relevant to the appeal tonight, and we would ask that you not rely on those in your decision. As to the bin pads, the townhouse location, and the balcony on Unit C, again, we just simply cannot find anything in the appeal to the effect that the zoning administrator's decision was somehow incorrect based on the EHO ordinance as it is today. The EHO ordinance is the law in Arlington County. It needs to be followed, and the zoning administrator did exactly that. In fact, she made her finding that the plans and application do meet all the requirements, and in so doing, she issued the permit. As was pointed out at the beginning of tonight's meeting, we do defer to the zoning administrator's decision in these appeals. I think it's worthwhile pointing out that, in fact, Mr. Pomeroy is the one who, in his appeal, incorrectly applies the zoning ordinance in this instance. So already noted before, there is no mechanism for neighbors to comment on the aesthetics or other desires. For example, this is not a 4.1 site plan. This is a by right EHO permit. And then I would also note that, as was pointed out earlier, as to the bin pad location, there was some question about applying the stormwater regulations to that, as well as coverage requirements for the bin pads. But those, as have been pointing out in our response, and the zoning administrator's response as well, simply do not apply the way that Mr. Pomeroy thinks they do in this case. So to wrap up and in conclusion, again, we would believe that Mr. Pomeroy has not demonstrated standing in his appeal, nor has he demonstrated anything incorrect in the zoning administrator's decision. And so for that reason, we would also ask that you affirm the zoning administrator's decision. So thank you very much. I look forward to any questions.
Thank you. Mr. Pomeroy, representing the appellant. Yes, Malice.
Great.
Can you raise the podium up so we can get a clear, there's a button with arrows on it that should allow you to raise it up.
On the right, right here, okay?
Thank you. Right, keep going so we can get better audio.
Keeps going back down, yes.
Okay.
It does seem to be going down.
Oh, got the touch.
Okay. All right.
Good. Would it be possible to make the PowerPoint larger? I assure you that people behind cannot see it as it is. Ah, much better. Good. Great. Thank you. Good. Yeah, I'm John Pomeroy, and just for glad to be here. Well, not glad, but anyway, I respect the hard job you have to do as far as a member of the board, but I ask you to please give full consideration to what I'm about to present to you. I'm referring, just to a note here in the PowerPoint, is that I will use for brevity the term Hartsock. It will cover not only him personally, but Cherry Hill Custom Homes, as well as 1521 Vale LLC, the current owner. Good. I've lived here since 1979. My son here now lives in Fairfax. I raised him all through the school systems, public school systems in Arlington. My daughter now lives in Brooklyn. She and her husband and the new baby. The house above is where I lived from 79 to 2006. And I have, at least throughout that time, grown to love Arlington. This is my neighborhood out of Google. There's 2400. You can see there are some trees, big trees behind it. I live right there. You enter off of Monroe Street there, turning off of Nellie Custis. The reason I'm putting this up is you need to understand that it will have an impact on the full neighborhood, the choice of putting 3 townhouses at this location. So, this is the house itself. It's a nice brick house. And as was mentioned, yeah, I always thought it would be upsized some, but I thought at least the character would be preserved. You can see the 2 big trees behind it. Next. Yep. This is the backyard. You see again 2 big trees behind it, and 2 camellia bushes right there. As you can see, it's a beautiful garden. The tree here, the critical root zone, comes really over to this area here. Similarly, the roots of this tree are going to, both of them are about 5 feet in diameter, are going to extend all the way into this area here. Yeah, the permit process is secretive and non-transparent, and I, like many citizens here in Arlington, don't like the fact that we're shut out of the process. A big point was made that I will make the point, I couldn't even get the copy of the application early on. I had no opportunity to talk to Mr. Hartsock as far as, hey, might you consider not putting the townhouses quite where they are? And there was just no opportunity to know that because it was all secret. And I also find it troubling that there's no examination whatsoever of due diligence with respect to his past construction projects within the county, no disclosure, no interest in finding out anything about the reputation, integrity, or business practices. It's all focused upon filing an application that technically provides, hits all the squares it needs to, but the process does not go into anything that may protect Arlington residents against unscrupulous developers. Next. This is the plan as it is now. You can see it, just show you the existing site plan. Next. This is the approved site plan. You can see how it's moved to the back right there. And it is about as close to my line and to the back line as is legally permissible. This is the subdivision feasibility sketch that's going to be considered as far as subdividing the property. The point here is that Townhouse A, which is right here, it has over 50% of the property. The middle strip here is Townhouse B, and C here has about 30%. My point on that is that if I could have had some input, if he would have considered what I thought at all, there would have been a discussion about moving it over, equalizing the sizes of the lots, and reducing the extent to which it abuses, infringes upon my privacy and use of my backyard. Next. This just shows a little bit better as far as the size. That is a 40-foot wall. Next. This is the side, and this height here is 34 feet. The peak here would be 38. That's 30 feet. So next. There has been, again, by right, the provisions transfer to developers and take rights from Arlington residents. That's just a fact. That's the decision. I agree that it's under challenge now within the court, and we may know here fairly soon on that. And again, choices. Hartsock was left unrestrained to make site plan choices that destroyed the character, will destroy the character of the neighborhood, invade the privacy of the neighbors, reduce the value of our homes, and adversely impact our quality of life. Next. Okay, the adverse effects on value. I'll skip over the use and enjoyment. I've already pretty much covered that, but I got the initial estimate there, the assessment there, the value of my house as of January 1. I protested it. I argued then with the assessor who came, and he generally the valuations had increased within the county. He recognized my argument, backed up by 4 real estate agents, that this townhouse so near my back property line is going to undermine the value of the house, and he agreed to a reduction of the house value by $87,500. So it ended up being less than it was the year before. The only change that whole year, all of last year, was the fact that the application was filed in November, and it became clear by then that a buyer who might want to buy would take that into consideration as far as what he would offer. If the townhouses go forward, it's going to even reduce it more. This is the back patio of my house right now. Now you can see all the blue through the trees here. There's a big willow oak. All that blue is going to be a wall. It's just, now it could have been moved probably 20 feet away more than where it is, and then it wouldn't be quite the infringement that it is. But with the secret process, I had no opportunity to say, hey, Mr. Hartsock, why don't you move it a little bit? I was totally cut out of the process. And so the lawsuit. Yeah, it's pending. In fact, very soon on July 14, there's a motion for summary judgment, which will be heard on 2 counts, with the plaintiffs having filed the motion. If they prevail in that, as far as summary judgment, then it may have an impact. I don't know. The issues are over the advertising that was done. The more major issues, I think, will be the ones going to trial in July. And I do want to incorporate, again, by reference, that lawsuit and the claims in that lawsuit, because I do want to preserve those rights in my appeal to circuit court if that becomes necessary. Next. That basically was everything that worth covering here tonight from what I said in February. But more has come up, and that's what I want to focus on now. How much time do I have left?
11 minutes.
Good. I wrote a letter. It went online. It triggered a lot of information coming to me. This is not an issue that I'm bringing up now because I want to, but it's been basically forced on me. In a project that Hartsock did down in South Arlington at 1126 17th Street, a number of the neighbors were upset because he initially resisted any sort of compliance with removal of crumbling siding that included asbestos. And it took a considerable amount of effort to get him to finally comply with the requirements, to get in there the necessary inspectors, and to have the right team come in qualified to remove that siding. He had sent me a number of emails about that, about that problem. There also is a flooding problem that was created, and you can see here the problem surfaced at the initial construction level as far as the basement. The foundation, they continued to build it as far as the foundation without addressing it. Here the building's substantially completed. Water is coming out. Here ice sheets are forming on the neighbor's driveway. And all this went on for almost a year to get that problem corrected by Mr. Hartsock. This is what, whenever it rained a lot, this is what the neighbor, Jen Byrne, faced. This amount of muddy flooding would be across the front of her lawn with a high frequency, depending upon the storms that they were having. Now you could say, well, what does that have to do with my case, with my concern? Well, I do have a concern, and I was concerned about what was being filed in permits, requests for permits. I went ahead and I did file a FOIA request on May 14. On May 31, they notified me that the documents were available online. And what I found in there is what I'm calling the existing vegetation and tree protection plan. This is the sheet that gives the plan. It's got this area here that's supposed to show all the trees on the lot 2400, and also above that is the adjoining lot. They're a part of the 2411 Monroe, and I'm over here, and I will mention the trees on my lot are not shown, but anyway, it shows the various trees. This is what they call existing tree inventory. You bring that up here. You can see it shows out the trees are numbered, and this is the numbers here, 2 and 3. I note here right here. It's supposed to be a 12-inch diameter southern red oak. This one a 14-inch southern red oak, and they are both going to be cut down. Of note here is number 12, which is a willow oak. That's a specimen tree. It's on the list here for the county, and it will be entitled to additional protection. It's 60 inches in diameter there, and so 5 feet diameter tree. It's a big tree. It's listed here as off-site. Go ahead. This then is a blow up of that upper left portion. You can see right here is 2, and the CRZ, the circle around it. Number 3, again, this is supposed to be a southern red oak, and the circle around it. The big tree, the specimen tree, number 12 up at the top, you can see where its critical root zone, CRZ, goes down under the patio that far. Now, what Mr. Hartsock proposes to do is to not kill that tree. He's proposing to put some mats in there. Next one. He has written a letter, which he's obligated to do, to the McCurchins who own 2411. In there, he talks about the building there of developing the lot, and mentions that tree number 12 has critical root zone, and goes into the details there as far as the measures that he intends to put in place. But nowhere, the next one. This is a response letter, comment response that he put in. And this is the first page. Next one. Here on the this is page 5 here, but it goes into 5 there. Off-site trees, including specimen trees, have been shown. Other representations along those lines are contained in the follow-on as far as what response he was providing to the urban forestry. Next one. This is, again, the backyard. There are no southern red oaks. There are these camellias. They're just not there. But you do see this tree. This willow oak tree is here. Next one. There it is right there. The big tree behind the house, big tree to the right. And then the specimen tree is the one on the left side, not even as big now as this one here on the right. And it's not covered whatsoever. How could you not cover it? Next one. This is looking down the property line here, and you can see the one that somehow disappeared, the magical tree, is closer to the line than the specimen tree, which is behind it. Now, its critical root zone, of course, is going to go way down here, just as far as the other one did, overlapping under it. But I guess maybe it's not there. Next one. Misrepresentations. This could not have been done by accident. This was a clear misrepresentation of facts to one of our Arlington County authorities. And this is just something that this board and that we cannot tolerate this, because it undermines the regulatory process if developers feel that they can misrepresent facts and get away with it. And if it's discovered later on, then they only get a slap on the wrist. What I think is that he hoped to be able to put it over on the urban forestry people to the point that they would not realize it until it was too late. And that the reason was, you look at the clear language of 18.2, section here, 498.3. And I have a copy of that, of course, here, and refer to it in the statement that I gave you on paper. But this clearly is what occurs. He clearly made, in a commercial dealing jurisdiction of any department, who knowingly falsifies, conceals, misleads, or covers up by any trick, scheme, or device a material fact, or makes any false, fictitious, fraudulent statements or representations, or makes or uses any false writing or document, knowing the same to contain any false, fictitious, or fraudulent statement or entry, shall be guilty of a Class 6 felony. And felonies of that nature have been in the news quite a bit here of late. Next one. Yeah, next. Oh, I'm sorry, that's it. This is why I think he did it. This puts the obligations on him with regard to the destruction of that tree. And I think that he thought that he could get the permit from urban forestry and avoid having to comply with this section. And if he got caught, it would be after he went in, demolished the tree, the site and the house, and cut the roots of the one right beside the fence without any sort of consent. You notice the second tree was not covered at all in the letter to the McCurchins. It only covered the specimen tree and made no reference to the one that he left out. So I am concerned as a resident of this county that we cannot, that there is responsibility, that the zoning board has been given a lot of responsibility, that the zoning office has responsibility, and it can't just be a technical check the box process. It has to be deeper than that from the standpoint of disclosure by the developers and then due diligence by the staff. And when we have a clear example like this, that this developer has some real issues and not just fictitious ones or past ones, but a current one that we face right now as far as his attempt to develop this property. I think it mandates a reaction by the board. I have, how much time do I have?
1 minute.
1 minute, okay. I have, in the back of what I gave you, I propose an alternative resolution, and I'm relying upon language out of section 10.4.1 as far as the fact that issuing the permit to him would not support the environmental goals. Oh, I see right now here of tree conservation, nor preserve or enhance valued neighborhood features, not meet the objectives of the EHO program of granting EHO permits to applicants with a consistent record of meritorious business practices. We cannot establish a record in this county of granting EHO permits to those who do not merit them. Good.
Thank you. Mr. Bowen, speaker, can you bring up the speaker list?
Yes, we will move back to our original PowerPoint presentation momentarily. But I can note that the first speaker we have listed is Andrew Crouch.
Is Mr. Crouch with us? Mr. Crouch. Is Miss Ruminger? No, you come on down, and if Mr. Crouch makes himself known, we can circle back.
Hello, my name is Kathleen Rubinger, and my address is 2732 North Radford Street. I'm in the Dover Crystal neighborhood as well. I have lived at my current address for 35 years, and I am here to object to the approval of this project. I had a lot of comments about the county's policy, but I will reserve those for some other forum. I would like to point out that this project will result in the destruction of mature trees and plantings, not only those on the property at issue, but on neighboring properties because of the excavation that will damage roots of these mature trees. Further, by permitting this project to almost completely cover the land and the plot of the land with an impermeable surface, destroying trees, approval of the project will result in a dramatic increase in the amount of stormwater runoff from the property, further damaging the environment. As far as the neighbors are concerned, and I will speak for myself, but for many other neighbors, this project will be a blight and an eyesore in the neighborhood. The coverage of the lot, the height, the style will mark the project as a misplaced, outsized monstrosity and aberration in our neighborhood. This is a sad but accurate description of the effects of approving this project. The valid concerns of residents have been ignored, and there has been a failure to fully consider the impact of these projects on the county's facilities, infrastructure, and quality of life. This is not what residents in this county expected or wanted when they purchased homes in this neighborhood, and it will drive other residents out. Perhaps that's the goal, to drive density to satisfy an increasing appetite for revenue to cover up failure to deal with responsibly with these kinds of planning issues. Thank you.
Thank you. Is Ms. Owens here? Ms. Owens? Dolores Owens? You can, there's an arrow on the podium on the side, on the front that you can
That's all
lower.
right.
You can lower it. Okay.
I have a big voice. My name is Dolores Leal Owens. I'm a 50-year resident of the Dover Crystal subdivision. I am a past member of the Arlington Notable Tree Committee and a past secretary of the Dover Crystal Civic Association under 2 presidents, one of which, ironically, is the former owner of 2400 North Lincoln Street. It's confusing in your responses to Mr. Pomeroy's filing. They seem to indicate that your function is only to make sure that the paperwork has been correctly done, I's dotted and T's crossed, and that the underlying issues of the case are beyond your purview and control. Please do not wash your hands of these appeals. Your position is a serious and powerful one that should be above the politics that resulted in the decisions giving birth to the current situation. The question of the 2 trees is in fact a major question here, as the comparison between their current value, aesthetically, greenhouse gas emissions reduction, and protection regarding global warming being considered as equal to a 15 or 10-foot sapling, which will take more than 20 years to replace the value of what is being lost. Make no mistake, given the siting of the 3 townhouses and the excavating necessary for the project, the attendant prolonged compacting of soil, this will all absolutely negative impact these existing mature trees, which, however, may take 2 or 3 years to actually die. And the result for that will be thousands of dollars to remove them, borne by the owners on whose property they sit. In addition, these townhouses are not compatible with the surrounding neighborhood. Words right out of your mouth. They sit there, 3 ugly houses. And if you saw that side view, that's what the neighbors will be seeing. That's what all of that side street will be seeing. And please, please listen to Mr. Pomeroy and take some action that doesn't fall back on, I'm just following the rules and signing off on this. Then why are you here? Thank you.
Thank you. Did I skip Mr. Zaramba at the beginning? I apologize. You were first on the list.
First of all, thank you for letting me speak my piece here. I know it's late.
I'm sorry, can you speak into the microphone so people online in the recording can?
Yeah, so I wanted to say thank you for allowing me to speak. I'm here as an individual. I've lived in Arlington for 30 years. This is my 4th house. I happen to live in 3601 Nellie Custis, where my kitchen window looks right at this property. I really want you to have 3 takeaways from this. One is there was no disclosure. I found out about this massive excavation, this massive project, 2 months after it was approved, when Dennis and Judy's moving van showed up. So there's been no opportunity for me as a neighbor, as a property owner, to be participate in this process at all. I think the second thing I'd like you to consider is this is a raised lot. You've seen the pictures. They're going to have to excavate thousands of cubic yards of dirt. And this property is only 500 feet from Windy Run. So all of that runoff, all that disruption, I can't believe that there wasn't an environmental study on this project, given it's so close to the Potomac watershed. So I think that maybe you should consider that as part of your deliberations. I think the third piece, which isn't really a statute piece, all due respect to the attorneys in the room, what's right? What is right here? The only people that get hurt if this goes forward is John and the neighbors. And I would say, my argument would say the environment gets hurt. If you deny this and you don't allow this project to go forward, the only one that gets hurt is the developer. And my argument is he hasn't invested a lot right now. He can sell this house and pretty much be made whole. So I appreciate you taking the time, let me speak, and sorry to be the last one before the adjourns this evening. So thank you.
Thank you. And Mr. Crouch, circling back, I don't see anyone online. I assume that there's no one in the room. Then I will defer to my colleagues for questions or comments. Yes, why don't we start with questions for staff? We won't go back and forth. We'll just try and keep it. So questions for staff. Ms. Malice, would you like to start? Can you turn on your microphone?
Could you provide some clarification on the relationship of impervious surface to lot coverage?
The zoning ordinance doesn't regulate impervious surface for this type of development. So lot coverage is defined in the ordinance. It's comprised of the coverage of the buildings and structures, structures of a certain size, and areas for parking. Yeah, I mean, if we want, we can read the definition, but.
So,
yeah.
So impervious surface isn't, in this case, is not related to lot coverage.
It's not a term that we use to regulate how much, right? I won't say that I feel like it appears in the ordinance a couple of times, but it's not, there is no maximum impervious surface area permitted or not permitted.
So any concrete pads that are, can't let that happen.
Yeah, I'm going to ask the audience to remain silent while we do our questions. The comment period has passed. Thank you.
So the pads are not included in the calculation of lot coverage because they are essentially patio size.
Right. We exclude paved areas that aren't used for parking unless they're over 8 inches tall.
Okay.
So, yeah.
Can I jump in with a follow-up?
Sure.
If this were a single family permit process, are those statements about the impervious surfaces still apply?
Yes.
Or are they treated differently?
It's the same.
And forgive my ignorance on the impervious surface issues, but I believe that we've seen from prior cases tonight that there is a relationship between impervious surfaces and planter boxes required. The more impervious surface, the more planter boxes you need.
So that's probably a requirement for stormwater management, which
Right,
is
correct.
not addressed in the zoning ordinance.
Which is not addressed in the zoning ordinance and not a requirement of the EHO permit.
Not by me.
Not by
Right.
you.
So I can't speak to what other departments who regulate other rules and requirements would mandate. to fulfill stormwater management. I don't know what those are.
Okay.
Sometimes people use underground tanks, sometimes people use planter boxes. It depends. And those could eventually impact things that are regulated by zoning, but they're kind of parallel reviews by different folks that all have to be met.
So I think at least I'm struggling with what are the requirements for an EHO permit, and that's I think some of the from I think the questions we get and the comments we get and the appeals we've been clearly getting over the last 6 months and the ones we will be hearing shortly, is that there's a big question about what is actually required to get an EHO permit, and then what would be being appealed. And I have a feeling we'll be talking about that a little bit more. But I see. Are you jumping? Are you...
I think she's saying it doesn't need to be determined now at the issuance of the permit. The stormwater issues have to be determined, but not in order to issue the permit.
That correct?
Yeah.
Okay.
Mr. Chairman.
Who? Ms. Mellis.
So just to finish that, it could be possible that the plans would now require additional mitigation for stormwater as they go through the process.
Sure.
There could be planter boxes, there could be, and what we typically see when we get an application is everything, it's already gone through the whole process. If, for instance, on the house that we saw tonight, there were planter boxes, and that was because it's already been determined when it came to us, the whole package.
I think I think typical BZA requests come when a project is going through the building permit review process, where things are much further along and
Right.
we have multiple disciplines weighing in on all of the things that are required that have to be reconciled. And so, yes, I think you typically see a traditional use permit request much further along
Right.
in the process than when these are being reviewed.
Okay. Just as an aside, maybe it would be helpful somewhere that was spelled out to people so that, people understood that requirement will be handled later down the road, but it's not something that needs to be discussed.
I've seen a draft. If it's not out, we are working on more explanatory materials that this is what's required for an EHO permit, this is what's required for a building permit, and kind of how the two work together to try to continue to educate people about the process.
Okay. So what about, we heard a lot about trees tonight. They're not part of the EHO?
There are landscaping.
Or are they?
There are landscaping requirements for EHO development. And I believe it's a certain number of trees must be provided. That varies depending on the number of dwelling units. But that's the extent, and that can be fulfilled either with existing trees or planted trees.
Right. And that does get done through part of the zone, through your zoning EHO permit review?
The EHO permit review process includes someone from the Urban Forestry Office who reviews every request. So they sign off and review the landscaping requirements.
So that has been done?
Yes.
In this case, okay.
And can you speak to what that review process entails? Like, what are the requirements for that? Right. I mean, so someone signs off on something, but what is it that they're signing off on?
I think the staff report has whatever the landscaping requirements are. I don't remember specifically, but it's a certain number of trees that it's arranged per dwelling unit. And so it's, I guess, demonstrating that either they're going to keep them or plant new ones consistent with whatever we require.
And do you, I'm sorry if you had.
Go ahead. Go ahead.
If so, hypothetically, and I think this will be an easy hypothetical, if I have a lot with 100 trees on it, and I tear down the 100 trees, as long as I plant the required replacements, that would meet this review?
Yes.
And would,
unless there was some other for zoning. I have no idea if there are other requirements that might pertain to tree preservation, but for zoning purposes, it's only what the landscaping requirements say in the zoning ordinance.
And we're here for zoning issues today.
Yes.
And so if we accept that there is a missing tree that would have been missing prior to that review, does that affect the analysis?
So that exhibit, I believe, referred to something that came out of the land disturbance activity permit review process, which again is a separate process, which we have no interaction with. So I don't know what the standards are for that, where it is, and has it been approved? Is it still under review? It could be that it's still being decided at this point.
But you told me that there was some zoning review for the tree. I forget the term of it.
I think, and Arlo, please correct me if I'm
Yeah.
wrong, but I think the difference is zoning has certain requirements for a number of trees.
Yeah,
per
no, and that's
unit.
that's my
And
question.
that they check that alone, and then there's a whole
Right.
set of other things
So-
that are going through a separate process.
So for that process, my question is, if there was a tree if there was a tree on the property before that review has been done, does that affect your review? Right. So we heard evidence tonight that there's a missing tree currently. Knowing that there's a missing tree, does that affect zoning's tree review?
The only thing that would affect the zoning review of the landscape requirements is whether or not they are shown on the proposed plans to be consistent with whatever the minimum they have to provide
For the end result, not the
Yes.
current result.
for the proposal.
Right. The finished proposal. Right.
Yes.
Okay. I think that answered my 3 questions. Sorry if I hijacked my colleagues. Ms. Malice.
An additional question. The issue of balconies was raised in privacy. It's typically on single-family homes. Builders don't often put balconies on upper stories, but it is permitted in a single-family home.
We don't have any specific requirements for prohibiting balconies in any location.
So the zoning does not
No.
address balconies in single-family homes or in EHO situations.
If it's within the development
Setback.
buildable envelope, yes, we don't.
And they do have to meet the setback requirement. They're considered a wall, just like any other wall would be.
Whatever design is proposed has to meet what the appropriate setbacks.
Thank
Yes.
you.
Ms. Freshman.
Just want to make an observation because we've now heard several of these cases. And one of the most frequent comments is that the neighbors don't have any input. They don't have any knowledge in most cases that someone is acquiring a property and going through this process. And as I understand it, the only response is if you find out within a certain number of days, then as an aggrieved party, you can complain and file an appeal. Is that correct? Essentially, that when the board adopted this ordinance, it's essentially a by right in the same way that if someone bought this same property and tore down the existing home and just built a McMansion, which might in fact look just as bad. At least some of the ones I've seen are pretty obnoxious. That's a by right development in the sense that if you meet all the criteria and setbacks and trees or whatever, then you can just go ahead and neighbors wouldn't have any input in that situation as well. And the only time it might even come up for discussion is if they were asking for something exceptional, in which case they'd be here. And then there'd be notice to all the neighbors and signs posted and all kinds of opportunity. So when I look at this, not so much this property per se, but we've heard quite a number of these cases and we already know of at least 3 more coming, that I'm very sympathetic to the fact that for whatever reason, this particular issue, which for anybody paying attention was bound to be controversial, is in fact a by right effort. And so there's nothing to preclude people from coming in and buying houses and making an application as long as they follow the elements of the ordinance. So I guess I'm not making a statement one way or another except to partially explain why this appears like such a secretive process. In some case, it's no different from a property going from a single family modest house to a single family enormous house, where in that same instance, the neighbors wouldn't know about it either until the house was torn down, and then they might be curious, but there was no obligation to or opportunity for community input at all. I find that disappointing because I think with all of the many meetings and hearings and outreach that was done as part of Missing Middle to come up with something that would increase inventory without, in my view, addressing affordability at all. I would have thought that it would be understood that it might be a fairly sensitive issue that would have some public input built into the process. So I'm disappointed that that's not the case here or any of the others.
Most everybody else.
I'm sorry, sir. This discussion is with the board and not with the public gallery. Thank you. Thank you. Any further questions for staff? I just will make a quick observation before we start questioning the appellant, is that I do think that the appellant has made an interesting point that 10.4.1c, which supports the environmental goals by encouraging tree conservation and planting, seems to be at odds with the ability of by right to raise a lot of all the trees. And I am squaring that with then the minimum requirement of planting new trees versus 100-year-old trees, for example. So those two provisions to me do seem to be kind of odd and contradictory. And I'm going to chew on that while we question the appellant, unless you have any comments to my comment.
I would just note that the specific standard for landscaping clearly says that the requirement may be satisfied with either existing trees and or by planting trees on site.
Which, again, to my point, is kind of contradictory to the purpose of the expanded housing option development. So, thank you. Ms. Mellis.
Could you elaborate your point? I'm not sure I'm following.
So section 10.4.1 of the expanded housing option development has 10.4.1 is the stated purpose of the EHO development option. And C says support environmental goals by ... tree conservation and planting options for reduced on-site parking requirements, right? And so if one of our goals of EHO is tree conservation and planting, then that seems contradictory to the provision that allows you to tear down notable trees, right? Trees that have existed for a long, long time, and plant new trees. Right.
So one is the policy and one is a regulation, or is they both regulations?
I think one is a policy statement and one is a regulation statement. And the regulation statement to me seems contradictory to the policy statement.
Which often happens.
But now is dumped in our laps to square the two.
Well,
go ahead.
No, go ahead. You finish.
No,
Well, I just think that, yeah, it's often true that there's disagreement as to how the regulations should carry out policy. But I think we're also kind of we can agree with it or not, but we are kind of and I know no one wants to hear us say this, but we're kind of stuck with the regulations are what the county board decided should go in as regulations. And the purpose, having a purpose that we don't think is met by a regulation doesn't really authorize us to add some more regulations there that don't exist.
And you know, and I think when we get, I'll have some comments, you know, further on, but I think that is just like one example of, you know, confusion, which is what, you know, clearly obvious of why we're here and there are so many people in the room. And I think that, you know, some more guidance, which I hear is forthcoming, I think would be useful for us and the public as a whole. The appellants, questions for the appellants? Anyone want to start us? I'm happy to do a quick one.
If you have some factual ones, yeah.
You heard, why don't you come on down? You heard the county when I questioned the county about the impervious numbers of calculations, that they are not, EHO development is not subject to zoning requirements for impervious surface area. And my question was, is that any different than a single family home, or are we being treated any differently, one versus the other? Because I don't think the EHO development ordinance speaks to that. Do you have a different opinion on that?
As far as from an understanding of the regulations, or as far as a personal opinion of the extent to which we need to encourage having driveways that are permeable and can feed the roots beneath them?
Well, I think driveways are required to be permeable, because I think in the zoning administrator's comment, she said that she accepted driveways, and for other surfaces less than 8 inches, and she can jump in if I'm wrong.
I didn't say they're required to be permeable.
No,
they count towards lot coverage.
Thank you. Yeah, that's exactly what I meant. And so, you know, I think we're here for the ordinance and regulations, not personal opinions. And so, you know, one of the major issues I see raised from both the oral arguments and the papers provided to us were the non-permeable trash bins, right? And so, do you have any support, or can you point me to some support of where that calculation went wrong?
Well, I did my best calculation based upon how I could read the plans, and then included them in the numbers. And it did not seem that they were already included.
But the zoning administrator's position is that they don't need to be included because they are less than 8 inches above the ground, and that there is no provision in the ordinance, the EHO ordinance, or the ACZO to allow for a calculation for hard surfaces that are less than 8 inches above ground that are not driveways.
I'm not sure why it differs, why it matters whether it's 8 inches or 7 or 4.
That's just the regulation before us.
Yes, as far as the effect of denying the land under there any sort of ability to absorb water, whether it's 8 or 2, it's going to be the same denial, and it's going to have the same increase on stormwater runoff.
Thank you. Do my colleagues have anything further for the appellant? Ms. Melchior?
Mr. Pomeroy, I thank you for your complete and heartfelt and thoughtful presentation. And I'm not sure that there aren't members among us that might be just as distressed as you in your circumstance. So I do appreciate that. A lot is being talked about the rule of law in the press, you know, having to do with national politics. And that's where I'm kind of stuck, is that the BZA has authority to do certain things, but it doesn't have authority to do everything. Do you not recognize the limits to our authority?
My concern is that there are limits, but some of the limits are self-imposed. is the application process was not forced upon you as far as making it so technical, so that with EHO permits, generally within a county like Arlington, somebody's got to be the gate guard. Somebody's got to do something to try to ferret out the unscrupulous developers from coming in and preying on the county residents. And right now, I don't see it in the EHO program as far as the application process. I don't see any due diligence going on with regard to the applicants. And I think there ought to be. And the reason I do here in this instance in particular is first, of course, what happened down in South Arlington, 1126, a year and a half controversy with neighbors because of unscrupulous behavior. And then again, I do think it's a Class 6 felony, what was attempted here from the standpoint of misleading the Urban Forestry Department. Who's supposed to take note of that? Is the Urban Forestry Department supposed to complain about it? Are residents supposed to find these things out somehow with FOIAs and do something? No.
You're not suggesting that the 5 citizens here have police authority.
I'm not suggesting that. Or you certainly could refer it to the Commonwealth Attorney, I think, as far as consideration of this, because I cannot see how the violation there as far as ignoring a tree that is almost impossible. How do you ignore a tree that big looming over the house? And then you develop a plan and consistently it denies the existence of that tree. And there seems to be a reason for doing it. I just think that it should not have even gotten that far from the standpoint of needing a better intake here from the standpoint of the application process to try to get due diligence done realistically about applicants and be able to protect the citizens. Because right now, in this particular instance, I don't think we're protected at all. I think I'm going to have, if this goes forward, I'm going to have another 18 months of taking pictures and putting in FOIA requests and doing my best to try to enforce, stop cutting corners and doing everything properly. And not making misrepresentation. That shouldn't be my obligation at age 75.
I'd like to bring us back to, the authority of the 5 members of the BZA, which are statutory, proclaimed. You're an attorney, so you probably read the statute and you understand what our powers are. Many of the things that you're concerned about are outside the scope of our authority that reside with the county board. For instance, the nature of this ordinance. Sorry, the nature of this ordinance is not, something that we created or can change.
I understand your limits. I don't understand why the zoning office, though, in designing the application process, did it the way they did, from the standpoint of not requiring the disclosure of past projects, gathering some information from the standpoint of how the neighbors in those areas, how they interacted with the contractor, the complaints, the violations, the problems that arose with county agencies, and trying to establish a developer. I have to believe that the good developers want that standard. They don't want to compete with somebody who's just in there to make a quick buck.
But you did make an important distinction between the zoning office, and which is part of the county government, and the BZA, which is the 5 of us here. We're different. We didn't make those rules.
No, I understand that. Rules. Yep. Yes.
So I'm not sure, I appreciate your pleading, and I think your presentation is something, that someone should listen to, that you should, take it to your elected officials, elect new officials, whatever it is. But we have to work within the scope of our authority, which is within the state statute.
Then I'll try to book an appointment with the Commonwealth Attorney. I mean, it should not be forced on me. There ought to be a process. If the EHO program falls, and it may, but if it doesn't, it's even more important that the zoning office take responsibility to try to eliminate the unscrupulous developers from participating in the process. Otherwise, it is a true disservice to the citizens, the residents of Arlington, the process is. And I firmly believe that because of what I've seen in this present instance. And I don't see why it cannot be addressed here with the resolution with the resolution to put it back to deny it, or maybe even to say, look, you've raised legitimate issues here regarding this developer. Let's defer it until September. Let's defer a decision till then and see what your FOIA request finds out, see what we can find out, the zoning office can find out. I assure you that county offices will be a lot more forthcoming with the zoning office than it's ever going to be with me. I've found that out over and over again with FOIA is there's a limit to what they'll give you, but the zoning office could get more. You could learn more what's happened with stormwater. You could learn more what happened as far as the asbestos problem or the poor construction practices that resulted in the flooding. It just seems to me something ought to stop this train right now, because right now it's going to run over me, it's going to run over my neighbors all around, and we're going to be dealing with it. And the process should not work that way. So I would put on the table then another resolution, and that is that this is delayed until September, and see what information not only that I can get, because I'll keep trying to get it, but what the zoning office can get from other offices.
Mr. Palmer, maybe we should consult with the zoning office as to whether that would be appropriate for them to even do.
I don't know what the question is.
So, an investigation of an unscrupulous developer, for instance, is that something in your purview?
No, it is not.
And is that something within the BZA's power to consider in an appeal of a EHO zoning permit?
I don't know how, if it has no root in the zoning ordinance or a decision that was made by the zoning administrator.
That is not within the BZA's power. That's the county's position. You can ask.
Yeah,
it's not within the power of the BZA, and we've cited that power in the staff report.
Thank you.
So that puts me fighting the battle for another. I mean, I've already fought it for 6 months. I get to fight it. I get to file now with the circuit court. I get to try to get more information to see what I am dealing with. With one arm tied behind my back. Excuse me.
Yeah, unfortunately, I mean, even if we tried to delay it, that would just put us a few months down the road, and we'd still be in the same position, because none of the issues, unscrupulous developers, fall within zoning purview that we get to review anyway at any point. So all these issues, the issues are out there, and I think certainly, we should try to get any offices in the county to look at these things that can, although the unscrupulous developers may come to more of a state type issue, but I'm just not sure we're going to be in any different position in 2 or 3 months to address any other issues. Because we review what the zoning administrator does. She approved a permit, and we're here to review really that permit, unfortunately, because I think, the presence of all these people here tells us exactly how concerned people are about these issues and how much of an effect they have on people. I have a brand new house in a lot right behind my own, and it's not fun having that big house moved to the maximum height right next to the fence line. But these are the issues that we're all facing and trying to deal with. And I'm sympathetic, but I'm afraid we as a board are not going to have a lot of ability to, fix all these things.
Are there any further questions, or should we move on to discussion? Let's close the public hearing and we'll have discussion or statements from my colleagues and myself. Thank you. Would anyone like discussion or to make a comment?
Mr. Chairman.
Ms. Nellis.
I can start it off just by saying that I probably speak for many of our colleagues to say that we regret that this has become the only avenue for there to be a protest against an ordinance that you feel strongly about. It was never the purpose of the BZA to be the gatekeeper or the arbiter of whether the EHO missing middle process is a good idea or a bad idea, whether it damages people, whether it helps people. That is simply not our role. And we sincerely regret that, I sincerely regret that we've been put into this role and that this is the only avenue that you have. Because what's unfortunate is it's not a good avenue. Our powers are very limited as to what we can do. And so it results in tremendous frustration to you and to others that have come before us. But this is not the option to fix, your concerns about EHO. We can only look at what the zoning administrator has done in a very specific case and see if we can find any flaws in the reasoning. But we are not in a position to help you with your larger concerns about the process, transparency, the difficulty in getting information, and your ability to shape what's going on in your own neighborhood.
You, Ms. Mellis.
And I'll just add to that, I think that's correct. We don't have a good way of addressing this. Part of that is because the zoning administrator is looking at what's required under the zoning ordinance, and there's a whole other set of rules and reviews being done by other offices that the zoning office doesn't see. Those reviews may not be finished. We don't have an opportunity to review those other rules. And it was created as a by right process, and that makes it difficult for anybody to get involved in, and yet it has a great effect on everybody's, properties and what's going on around the community. So I think that's kind of where we are, though.
Thank you. I believe this appeal raises multiple genuine good faith issues and questions concerning the by right EHO permit approval process that the county board approved. And that's evident from the multiple appeals, the packed room we have here, which we had a packed room the last 2 or 3 of these appeals, and I would anticipate we will continue to. But the county board in their ordinance created this as a by right process and not a use permit. And I know everyone here patiently sat through 8 use permits where we weighed the tree canopy, notable trees, whether the project was injurious to the neighborhood, a compatibility assessment, which at times was a very laborious discussion with our applicants about how the neighbors felt about their project and if they did their outreach. But all of that, which is what this appellant has basically raised, doesn't apply to the analysis of an appeal. Our appeal today is whether the zoning administrator erred in her approval And the law requires us to give deference to the zoning administrator, which can be overcome by a preponderance of the evidence from the appellant. But we're required to presume that the zoning administrator was correct. And the evidence before us today was more use permit based and not appeal based. And if this were a use permit, I think that this board would have different opinions. But this is not a use permit that is before us. This is a zoning appeal. The issue, the major issue that is before us, in my interpretation of the issues before us regarding this specific appeal, was the calculations based on permeable or impermeable surfaces. But it doesn't appear that the zoning administrator made a mistake. She presumed correct, and I have not seen evidence that would overturn that preponderance of the evidence standard. I think that as I think a few of my colleagues has mentioned, if this were going in our backyard, like we would feel very similar to a lot of people in the room. And I think our hearts go out for everyone who's involved in this process. But we are not the appropriate venue. These issues should be raised with the county board, the state legislature, district or circuit court in their processes that are available, and various administrative agencies within the county. But I think my view, and I think it's clear where this board's view is that we just don't have that legal authority. And if we were to break with that, we would be overturned by the circuit court and probably laughed at. We don't have the authority to do this, as much as I think there are more than one of us who would love to be able to do that, but we just don't have that authority to do it. Anything further from my colleagues?
Motion.
Ms. Freshman?
In the appeal V-11960-24-APP-1, I move that the Board of Zoning Appeals uphold the decision of the zoning administrator.
Second.
A motion by Ms. Freshman and seconded by Ms. Viprowski for upholding the zoning administrator. Is there any further discussion? Ms. Malice?
Mr. Chairman, staff had included a finding statement in our proposed motion, and I wonder if we want to review that and decide if we want to include that.
You reference a page, Ms. Malice?
It should be right in the motion. Bottom of the staff report here.
Yep.
See it?
I'm reading.
Or it's in the whereas.
Yeah.
I see. So I think we should determine whether that finding, we're in agreement with that finding. There's two, that the BZA finds that the facts are as stated in the staff report.
It's very hard for us to hear what you're saying.
Wow. So I just was commenting on the two whereases in that the BZA finds that the facts are as stated in the staff report. That's what we agreed to. Staff report being your portion of the document rather than the whole package that we got, because the whole package included the appellant's version as well, correct? So when you say...
So maybe we can make clear that the staff report references the memorandum dated June 6th.
There you go.
Because I think that's all it is and not the attachments.
Right. So I would ask for a friendly amendment to amend the BZA finds that the facts are as stated in the staff memorandum in the staff report dated June 6th.
I hear no objection.
No.
A motion made by Ms. Freshman, seconded by Ms. McCroskey, and updated by Ms. Malice, amended by Ms. Malice. Is there any further discussion? I will call the roll. Ms. Malice.
Aye.
Ms. Freshman. Ms. Clark.
Aye.
Ms. McCroskey.
Aye.
Chair votes aye, unfortunately. Motion to uphold passes 5-0. I believe this board has some minutes to approve.
I move approval of the March 2024 BZA work session minutes and the May.
Separately.
What?
We're going to have a recusal, so we need separate, or an abstention.
What'd you say?
We're going to have an abstention for the minutes, so we need them brought separately.
One set at a time. Pretty soon we'll actually today. Gary.
Judy's not doing it?
I think Judy just referenced the first ones, didn't she?
She was
said March.
she was about to do the second one too.
Oh,
and we have to
okay.
separate
No,
them.
but
Okay.
I think she was just waiting for quiet.
Yeah,
to get there.
that might be. Can I ask everyone to keep their voices down and exit the room if they're going to talk, because we're trying to finish our work. Can I ask everyone to take their conversations to the hallway, please?
We used to play soccer together.
Can I ask everyone to take their conversations to the hallway, please? Thank you. I'm sorry, Ms. Freshman, we have to do the minutes separately because Ms. McCroskey wasn't at the work session. We have to do passage of the minutes separately for each. There's 2 minutes to pass. We have to do them separately. Anyone?
Is it March 12th?
March 20.
I move passage of the March 20th work session meetings.
Is there a second?
I'll second.
For passage of the March 20 work session minutes, motion made by Ms. Malice, seconded by Ms. Clark. Hearing no discussion, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. Clark.
Aye.
Ms. McCroskey.
Abstain.
Chair votes aye. Motion to pass March 20 minutes passes 4-0 to 1. Any further motions?
What's the date?
May 10.
Mr. Chairman.
May 15th.
15.
May 10, it says May 10 on the screen.
Oh.
Is that not right?
That's a typo. It should be May 15th.
Thank you.
Is it the 10th or the 15th?
15th.
15.
Oh, okay.
Mr. Chairman, I move approval of the May 15 minutes.
We have a second.
I'll second.
A motion for approval of the May 15th BZA minutes by Ms. Malice, seconded by Ms. McCroskey. Hearing no discussion, I'll call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. Clark?
Aye.
Ms. McCroskey?
Aye.
Chair votes aye. Motion passes for the May 10 minutes 5-0. I see that we have a item ZHO 230040 reissued. Is that Mr. Rissy or Mr. Bowen want to speak to that?
I love, unless you want to speak to it, I can
Love
speak to it. Okay.
Okay.
We had a EHO appeal that was slated to be heard at the February 22nd hearing. The permit was rescinded prior to the hearing. The permit has been reissued at this point, about a week ago.
Has any appeals been,
No new appeal has been filed at this time.
and is that on the tracker page?
Yes, it is.
So the appellant will have some notice because it's on the tracker page?
It's, yeah, that's on a tracker.
Because it's got the same appeal number. Is that the same appeal number 440, or did it get I'm sorry, did it get a new ZHO number?
It should be the same EHO number, to my
So
knowledge.
practically stand, I mean, I guess a question I have for some lawyer in the room is, does that appeal still stand because it's the same number?
I will defer to the lawyer in the room.
No.
No. Okay.
It shouldn't be the same appeal number.
I'm sorry, not appeal number.
Same
Z
permit number. I think that's the.
Yo, permit number.
Excuse me. Yes. I don't know. So it is the same appeal application? Is that the question?
To my knowledge,
So
Is the appeal still in effect?
Is the right? So it, ZHO 230040 has been appealed, and now it had been, I don't know, changed, overruled by the zoning administrator as not valid, and now the same appeal is the same ZHO is moving forward. So what is the status of that appeal?
Okay. I'm going to do my best. The permit was issued, then it was
It was
rescinded.
appealed. Well, it was appealed first.
It was appealed, then it was rescinded. So
The
that
permit was
rescinded.
rescinded.
Yes, the permit was rescinded. So there was no appeal anymore. The BZA there was no action, like nothing happened. It
And-
was like,
So is this a new appeal is this a new permit that can be appealed?
Newly appealed.
Yes.
it's not a new permit because the permit didn't exist because it was rescinded.
Would
So now
Now
it's a do-over, basically. It's
It's a new decision that's
Yeah.
been made.
It's a new.
the whole process starts again.
That can be appealed in
Yes.
30 days.
Correct.
Can
So the timing, everything starts anew.
10 days ago.
Whenever it was issued, I don't know the date.
Would
So would somebody know with the same number that was the?
That's what I was about to
Why
ask.
does
Is it too much to ask for someone from the county to let the appellant know that it's been reissued?
it's on it's publicized like everything is
Same
publicized.
I mean,
number.
they went out of their way to appeal the first time, and they're probably not going to check it every day for that appeal to go back. So I just think out of
If they
fairness,
look at
someone
the
should
number,
tell
they're
them.
going to think it's just their old appeal.
And we're going to, just to avoid a fight in the future.
So
I
the
think it would be in the best
status
interest.
changes, right? Every permit, every expanded housing options development permit has a different status on the tracker. When they come in, if it's been denied, if it's in review, right, it changes. So to assume, like you're presuming that someone's going to look at something that they know was rescinded and not notice that it's now been approved.
I'm just saying it might not be on that appellant's radar that it had the possibility to be renewed under that same number. And I'm just trying to avoid a fight down the line.
It's also by address, right?
I can
That's
also,
the only way you can look it up. It's also by address.
I can tell you that it is a matter of public record that the appellant on the first version of the permit regularly files a FOIA request to determine the status of the permit, the former permit. The appellant is very knowledgeable in how to do that. She does it. I see it come through
I just think it would be a good faith.
quite regularly.
Yeah.
If the BZA would like to notify the appellant, the BZA is quite able to do that. And the county will certainly take that recommendation.
Yeah, I just think, like I said,
under
I just think it would be a good faith effort on the
advisement.
county's part for openness and
Totally,
transparency.
totally.
So, and I'm not, we don't have the power to tell the county what to do.
No,
I'm just,
obviously, no, I get it. And we will, we'll do what we need to do. And I feel very confident that what our measures are, are under control and are properly noticing the public of our permit process.
and I was giving no indication counter to that.
I get it. I totally understand the meaning behind everything.
I'm just trying to avoid any, right.
Absolutely. Absolutely.
Mr. Bowen, the last item I see is 2023 BZA annual report. I have, for the county's information, I have drafted a cover letter and have distributed it amongst my colleagues. I think that it is pretty good and almost ready to go. My question about the annual report was, we had given you a couple items of feedback, and I haven't heard if there had been any changes to the last draft, which was quite some time ago. And so I think that is the last hold up for the letter to go out.
Yeah, and if Mr. Rissi is online, I know he was working on those comments recently to address them, so he may be able to speak to whether or not everything's been completed on that front.
I'll double check that and get out a new version to everyone by the end of the week.
Excellent. And I think my colleagues can obviously disagree with my assessment, but I think that the letter has been sent out to everyone. I've gotten some comments, have some minor changes to make, but I think from our perspective, if we see the next version of the report, we're probably pretty close.
Okay, sounds great.
The agenda having been completed, this hearing is hereby adjourned.